A pleasant good afternoon. Colleagues, senators, central staff, Senate staff, testifiers, our listening and viewing audience. The 36th Legislature of the Virgin Islands Committee on Rules and Judiciary hearing for today, Thursday, April 23rd, 2026 is hereby called to order. Before, as I always do, before going into the root of our meeting, I want to just give a little bit of tidbits of what this month of April, besides Carnival, celebrates. We have the Sexual Assault Awareness Month, turns 25 this month. And also, this month, we also commemorate and recognize the month of April as National Child Abuse Prevention Month. And also we have, and this one is very important to me because I served as a volunteer number of years. This whole week, in fact, is the National Volunteer Appreciation Week. It's celebrated yearly in the third week of April. National volunteers, they play such a critical role in what we do as a community. Whether you're a Girl Scout leader, whether you're leading a civic organization, volunteerism is really at the heart of what is America in our world. We have a number of persons who volunteer as Red Cross volunteers, as well as those who volunteer also for USO. And so it plays such a major role, even in teaching. You have grandparents who come into the classrooms as grandparent volunteer. So I want to encourage that level of volunteerism in our community to see things move along in a much better and more cohesive manner. I remember when I was a volunteer, people used to think I was getting funding from and getting paid as the president of the St. Thomas St. John Environmental Association. That was not the case. It was all volunteers. So I really want to salute all our volunteers, and also to mention on that line that we are also celebrating we celebrated yesterday Earth Day, and anyone who wants to contribute or know what to do about Earth Day activities, which you could still expand to today and tomorrow and the weekend, visit the earthday.org website, and it has a very powerful statement there. So let us all make a commitment to take care of our earth, to take care and be volunteers on our earth, to whether it's cleaning up your own neighborhood or someone else's neighborhood, wherever we are. Help take care of our beautiful Virgin Islands. And finally, I started out with that, the St. Thomas Carnival comes to its culmination next week, and I wish everyone a happy and safe carnival in advance of all of the festivities. Now, we started today's meeting later than we had planned, and we sent out the notice a couple of weeks ago that we were going to start the meeting today at 10 o'clock. And if anyone knows me, I'm cut from a real old cloth where I like to start on time and I respect people's time. And so we had to push that time frame back twice. So to meet with our team at the Virgin Islands Port Authority, as well as their P3 contractors who is building up our new airport, and to get basically an update on where we are with that. So it was a critical meeting, and it was very important for for all of us where we are and where we will be going forward to. And so it was necessary that we push back the meeting to really accommodate that critical meeting. And I want to thank the nominees as well as their support group who are here in the chambers today for being able and, more importantly, willing to pivot with us so that we could get the people's work done. I was not going to cancel the meeting, even though that was something, or postpone the meeting, even though that was something that we were contemplating based on the discussion. But because it is very important for us to make good and try to get things moving and not delay much further. So with all that being said, Madam Clerk, kindly proceed to roll call.
Senator Angel L. Bolques Jr. Present. Senator Bolques Jr. present. Senator Kenneth L. Gittins. Senator Gittins absent. Senator Alma Francis Heiliger. Present. Senator Francis Heiliger present. Senator Carla J. Joseph. Present. Senator Carla Joseph present. Senator Clifford A. Joseph Sr. Here. Senator Joseph Sr. present. Senator Avery L. Lewis. Here. Senator Lewis present. Senator Milton E. Potter. Here. Senator Potter present. Madam Chair, you have 6 members present, 1 member absent.
Thank you so much, Madam Clerk. We do have a quorum. Again, I want to thank all of my colleagues for being here and present. Madam Clerk, do we have any correspondence?
No, we do not.
Thank you so much, Madam Clerk. Madam Clerk, at this time, I'd like to recognize the presence of non-committee member, Senator Ray Fonseca. And now, Madam Clerk, kindly proceed with reading Block 1 of today's agenda into the record.
Please be advised that the 36th Legislature of the Virgin Islands Committee on Rules and Judiciary has scheduled a hearing for Thursday, April 23rd, 2026 at 1 p.m. in the Earl B. Attlee Legislative Hall on St. Thomas. The purpose of the hearing is to receive testimonies from the governor's nominees and to consider the following legislative measures. In Block 1, nominees: the Honorable Denise M. Francois, governor's nominee to serve as justice in the Supreme Court of the Virgin Islands. Ms. Renee M. Andre Esquire, governor's nominee to serve as judge at the Superior Court of the Virgin Islands, Division of St. Thomas, St. John. Senator Joseph, this ends the reading of Block 1 of today's agenda.
And thank you so much, Madam Clerk. I know we have 2 judicial nominees here. And in this block, Block 1, we have the Honorable Denise M. Francois, and she's the governor's nominee as a justice, associate justice to the Supreme Court of the Virgin Islands. And next, we have Ms. Renee M. Andre Esquire, the governor's nominee for judge of the Superior Court of the Virgin Islands, Division of St. Thomas and St. John. The committee is going to stand in a brief 2-minute recess, and then we will go right into the nominees. The committee stands in recess for 2 minutes. And we are back on the record. And we are back on the record. Okay, at this time, I'm going to ask the nominees to kindly stand and raise your right hand. Do you solemnly affirm under penalty of perjury that the testimony you will give to this committee will be the truth, the whole truth, and nothing but the truth to the best of your knowledge and belief? Okay, both nominees have said that they do. At this time, we will recognize the Honorable Denise M. Francois, the governor's nominee for Associate Justice of the Supreme Court of the Virgin Islands, to proceed with placing on the record your submitted testimony.
Thank you. Good.
Speak into the mic. Pull it closer to you, Judge Francois.
Is this better?
Just a little up. Put it up. Yes. There you go. Proceed.
All right, thank you. Good afternoon, Madam Chair, Senator Joseph, Senator Milton Potter, Senator Avery Lewis, Senator Angel Bolques Jr., Senator Alma Francis Heiliger, Senator Clifford Joseph, Senator Fonseca, members of the public, friends and family in the audience, and any other senators of the legislature that may be listening. My name is Denise Francois, and I am humbled and honored to appear before you as Governor Albert Bryan Jr.'s nominee as an Associate Justice to the Virgin Islands Supreme Court. Thank you for the opportunity to appear before you today. I am the daughter of Faye and Donald Francois of St. Thomas and the older sister of Monique Francois. I was born in Washington, D.C., while my father was finishing his engineering degree at Howard University. We then lived in Seattle, Washington, and San Jose, California, before returning to the Virgin Islands in 1969. I have a Bachelor of Arts degree in political science from Amherst College in Massachusetts and a Juris Doctor degree from the University of San Diego School of Law. After graduating from law school, I returned to St. Thomas and worked at the law offices of Maria Tankinson Hodge until I became a partner in 1991, and the firm became known as Hodge and Francois. While practicing law, I also served on the Virgin Islands Bar Association's Ethics and Grievance Committee, was elected president of the VI Bar Association in 1996, and served on the District Court Civil Procedure Rules Committee. As an attorney, I tried cases in the District Court of the Virgin Islands, the Superior Court of the Virgin Islands, and argued before the United States Court of Appeals for the Third Circuit. My greatest honor and contribution to public service has been serving as a judge of the Superior Court of the Virgin Islands since November 2013. I am one of 8 general jurisdiction trial court judges of the Superior Court who preside over both civil and criminal cases. As of March 25, 2026, I had 356 cases, of which 22% are criminal and 78% are civil. Criminal cases include everything from driving under the influence, unlawful possession of firearms, assault, kidnapping, sexual assault, embezzlement, larceny, burglary, extraditions, to murder. And that is not an exhaustive list. Civil cases include, but are not limited to, petitions for writs of habeas corpus, enforcement of construction liens, recognition of foreign judgments, foreclosures, actions to quiet title, personal injury, and other tort actions such as defamation, wrongful discharge, employment cases involving sexual harassment and discrimination, recovery of possession of real property, partitions, corporate derivative actions, shareholder actions, contracts, commercial litigation involving millions of dollars, products liability, wrongful death, medical malpractice, legal malpractice, and more. My caseload also has a significant appellate component, which I believe should prepare me should my nomination to our highest court be approved. The appellate work that I have done includes addressing appeals from the Magistrate Division of the Superior Court that includes small claims and evictions, as well as appeals from various government agencies such as the PERB, the Public Employees Relations Board, the Department of Licensing and Consumer Affairs, the Department of Labor, and the Virgin Islands Police Department. And once again, that is not an exhaustive list. In addition, while a Superior Court judge, I have served as a designated justice of the Supreme Court in 4 separate cases, and once as a member of the panel of the Appellate Division of the District Court, comprised of 2 district court judges and myself. I have also been active in the administrative aspect of the VI Judiciary with regard to procedural rules and non-judicial operations of the Superior Court. In 2016, I was the first chairman of the Rules Advisory Committee, the Civil Rules Advisory Committee, and under my leadership, the recommendations for the Virgin Islands Rules of Civil Procedure were adopted and promulgated and turned in on schedule. I've served as a member of the Judicial Management Advisory Council since 2022. Effective September 11, 2025, I was appointed to serve as the administrative judge for the District of St. Thomas and St. John by presiding Judge Jessica Gallivan. These positions have also prepared me with respect to the administrative aspect of the Supreme Court, the VI Supreme Court, which does more than simply review appeals from the Superior Court. Everything that I have been able to accomplish could not have been possible without the support and assistance of mentors, judicial colleagues, and the very dedicated, professional, and hardworking staff of courtroom clerks, law clerks, marshals, and my indispensable judicial secretaries, who are essentially paralegals. As a judge, my conduct both on and off the bench, in public and in private, is governed by the Virgin Islands Model Code of Judicial Conduct. This code requires judges to maintain the dignity of the judicial office at all times and avoid both impropriety and the appearance of impropriety in their professional and personal lives. For example, Rule 210 of the Model Code of Judicial Conduct prohibits judges from making public statements that might reasonably be expected to affect the outcome or impair the fairness of a matter pending or impending before any court, or make any non-public statements that might substantially interfere with a fair trial or hearing. Also, Rule 2.10 prohibits a judge, in connection with cases, controversies, or issues that are likely to come before the court, to make pledges, promises, or commitments that are inconsistent with the impartial performance of the adjudicative duties of judicial office. In keeping with the Model Code of Judicial Conduct, I aspire at all times to conduct myself in a manner that ensures the greatest public confidence in my independence, impartiality, integrity, and competence. I believe that I've demonstrated that I have the ability to capably serve as an Associate Justice of the Supreme Court of the Virgin Islands. If approved by the legislature, I will continue to work to resolve all cases in an independent, fair, and thoughtful manner. And while my parents are no longer with us, they impressed upon me the importance and rewards of public service with the government of the Virgin Islands, and that is a legacy I wish to continue. That concludes my statement. I am happy to answer your questions at this time, so long as they do not involve matters that may come before me or which are pending in the courts of the Virgin Islands. Thank you.
And thank you so much, Judge Francois, for presenting your testimony at today's hearing. At this time, I will ask Attorney Andre if you can proceed with placing into the record and reading into the record your testimony before the Committee on Rules and Judiciary. Attorney Renee Andre, kindly proceed.
Thank you. Good afternoon, Honorable Committee Chair Carla J. Joseph, distinguished members of the Rules and Judiciary Committee, non-committee members, family, friends, colleagues, and members of the listening and viewing audience. I appear before you today deeply honored and humbled by this nomination. I give thanks to God, without whom none of this would be possible, and to my mother, whose unwavering faith, prayers, and sacrifice have sustained me throughout my life. Her strength continues to guide me. I also extend my sincere gratitude to Governor Albert Bryan for the confidence he has placed in me, and to this honorable body for the opportunity to appear before you today. My name is Renee Marie Andre, and I am a proud product of the Virgin Islands community. My roots in this territory run deep, grounded in generations of family and service. I was raised within a close-knit, multi-generational family, deeply rooted in St. Thomas, from the Tutu high-rise community to 1B Congans Gata, where I learned the importance of community, service, and accountability. I am the daughter of Phyllis M. Andre and Donald H. Andre Jr. My mother is a woman of deep faith and resilience who raised her family while building a professional career and serving in ministry. My father dedicated his career to public service as an engineer technician within the Virgin Islands government, contributing to major infrastructure projects. I am also the great-granddaughter of Alton A. Adams Sr., whose legacy of leadership and contribution to the Virgin Islands community is well known and remains significant to this day. From an early age, I understood that law would be my calling. What began as a childhood aspiration in the second grade at Lockhart Elementary School matured into a lifelong commitment to justice, fairness, and public service. My academic journey reflects that commitment. I attended the Charlotte Amalie High School, where I graduated with high honors in 2000. During that time, I participated in moot court, an experience that sharpened my advocacy skills and introduced me to the discipline and structure of legal reasoning. I attended Payne College as a presidential scholar, graduating in 3 years as valedictorian at the age of 19, and earning a Bachelor of Arts in Psychology with a concentration in counseling. I later attended West Virginia University College of Law as a W.E.B. Du Bois Fellow. During law school, I distinguished myself academically, earning Cali Excellence for the Future Awards in torts, civil procedure, and legal research and writing. These achievements were not simply academic milestones. They were the foundation of the analytical rigor, discipline, and attention to detail that are essential for judicial service. One of the most formative experiences in my legal development was my service as a law clerk to the Honorable Curtis V. Gomez at the District Court of the Virgin Islands, first as a third-year student in law school, and then as a full law clerk without application. In that role, I conducted extensive legal research, drafted opinions, and assisted in the management of a significant caseload, including both trial and appellate matters. It is there, under the tutelage of Judge Gomez, that my skills in careful, meticulous, and objective legal research and analysis were honed. This experience provided me with a comprehensive understanding of courtroom procedure, evidentiary standards, and judicial decision-making. It also gave me a profound appreciation for the impact that judicial rulings have, not only on the parties before the court, but on families and the broader community. Following my clerkship, I entered private practice with the law offices of Margie Rawls Roberts, PC, where I have spent more than a decade representing individuals, families, and businesses across a broad spectrum of legal matters to include criminal, from misdemeanors to first-degree murder and RICO on the federal level, family, custody, guardianship, adoption, divorce, involuntary commitment and juvenile matters, civil, contracts, real estate, corporate, probate, tax and economic development matters, and more. During my years in private practice, I remained committed to public service, accepting court-appointed matters at both the local and federal levels, and by being among the few attorneys who joined the indigent defense and family court panels when they were first established. I have also had the privilege of being called directly by judges to handle matters before the court. As a partner at my firm, I have handled complex, sensitive, and high-stakes litigation, both civil and criminal. Outside of private practice, I have served as the chair of various committees and participated as a moot court judge and coach. This breadth of experience has prepared me for the demands of a general jurisdiction judge. Equally important to my qualifications is my judicial temperament. I remain calm, measured, and respectful, even in the most challenging and emotionally charged circumstances. I am not influenced by status or external pressures. I approach each matter with impartiality, and I am committed to ensuring that every litigant is heard with dignity and respect. I understand that the role of a judge is to listen, to evaluate, and to decide based solely on the facts and the law. I also bring a strong commitment to efficiency and access to justice. If confirmed, I intend to implement thoughtful case management strategies to reduce backlog and improve the timely resolution of cases. I will work to expand the use of technology within the courtroom and to make the judicial process more accessible and understandable for pro se litigants. At the same time, I recognize that efficiency must never come at the expense of fairness. Finally, I am deeply mindful of the ethical responsibilities of judicial service. I am committed to upholding the highest standards of integrity, avoiding both actual conflicts and the appearance of impropriety. In closing, I come before you as a product of this committee, raised here, forged here, and committed to serving our people. If confirmed, I will serve as a neutral and impartial arbiter, guided by the law, grounded in integrity, and dedicated to ensuring that every person who enters my courtroom is heard and treated with respect. It would be the honor of a lifetime to serve the people of the Virgin Islands in this capacity. Thank you for your time and your consideration, and I welcome any questions you have.
And thank you so kindly, Attorney Renee Andre, for reading your testimony into the record. At this time, I will go through the list and the order. Each senator will be asking questions. We'll first start out with Senator Clifford A. Joseph, followed by Senator Avery Lewis. Then we will have Senator Angel Bolques Jr. And next we will have Senator Alma Francis Heiliger, followed by Senator Ray Fonseca, and then Senator Milton Potter, Mr. President. And I will be the last to ask any questions of the governor's nominee. We're going to have one round of 5 minutes. Kindly proceed, Senator Clifford Joseph, with your 5 minutes of questioning.
Could I go for a second on this round? That's something like it.
Okay. What I will do, and the order was based on who arrived first. So what I will do based on the request, I will have Mr. Secretary, Senator Avery Lewis, kindly proceed with your line of questioning, your 5 minutes, and then Senator Joseph, you'll be ready to go second. Thank you.
Thank you, Madam Chair. Good afternoon. Colleagues, good afternoon to the testifiers here today, the nominees. Good afternoon to the listening and viewing audience, those in the audience here in the chambers today. Good afternoon to the people of the Virgin Islands. Judge Francois.
Yes, Senator.
You gotta come closer to the mic. How are you doing today?
Fine, thank you.
And you list out a whole lot of cases. You heard me here, nothing but noise pollution.
I'm sorry, I didn't catch that.
It's okay. Well, said I heard you list out everything you tried, but I heard nothing but noise pollution. But anyhow, that was
No,
a joke.
I have had noise pollution cases.
Okay, good. That's why they turned it down, because they knew you were here.
Oh, okay.
Anyhow, Judge Francois, having served extensively as a trial judge, how would you describe your transition in judicial philosophy from the trial bench to the appellate level, where the focus shifts from fact-finding to interpretation of law?
That was not on my list of anticipated questions.
Yeah, man.
But
I went to Google for that one.
But I will tell you this. There is not much of a change because the Virgin Islands Supreme Court, sir, as an appellate court, reviews the cases. So when matters go up on a review, it is a more holistic approach of the entire proceedings from beginning to end when addressing the issues that a party may have brought on for appeal. Whether I am hearing a case or whether I am reviewing a case and conferring with the other judges on a panel on appeal, I use and employ my same intellectual abilities and fairness and thoughtfulness. Anything I decide, I invest with a great sense of personal responsibility and wanting to get it right.
Thank you for that answer. Attorney Andre,
Senator Lewis,
how are you doing today?
I am doing well. How about yourself?
Excellent. In a close-knit community like ours, where many individuals are interconnected, related, and so forth, how will you maintain judicial independence while managing potential conflicts and public perception?
Oh, thank you for that question, Senator Lewis. As a judge, we have to uphold the judicial code of conduct, which requires that we must be fair and impartial and neutral. And so we are not able to sit on matters where a conflict arises or even a potential conflict. If that were to happen in a case before me, I will disclose that conflict and address it with the parties and take steps to resolve it, whether that may be obtaining waivers from the parties or recusing myself.
Good. At times, we often hear in this institution that there's a backlog of cases. Mm-hmm. Based on your experience and what you bring into the table, how do you think you'll move these cases forward if there is a backlog?
If there is a backlog, and thank you for that question as well. If there is a backlog, I would have to implement case management systems to ensure that these cases move on a timely basis. I'm aware that the Supreme Court has recently passed rules with case management protocols setting deadline dates for different types of cases and for motions. I would work and set up my own internal deadlines so I can target those outside dates and keep the cases moving along. And that also means that if parties come before me for continuances, that I will ensure that the continuance has a basis, the request for continuance has a basis, and that it's not just that the parties did not prepare adequately to move forward.
Thank you. Madam Chairwoman, I have no more questions for these nominees. Without a excellent job, continue doing an excellent job. I have seen both of them in their professional career, and there's no need for me to waste their time querying. I know they're going to do excellent job, so at the appropriate time, the both of them have my yea vote.
Thank you so much, Senator Lewis, and we're going to reserve the rest of your time should any questions pop up into your mind. But I do have a question for the Supreme Court nominee, Associate Justice. You mentioned in your testimony that you have cleared a significant amount of cases. Some cases, would you consider that a significant amount? I'm putting a label on it already, but you have a number of cases that you have had 356 cases, of which 22% are criminal and 78% are civil. What I was trying to get at is how many cases have you cleared and completed and found resolution that you have had to sit on? What's your rate? Have you have an internal rate that you've used?
I do not have a number on that, but I can tell you that for every case I may close, there are more coming in right behind it. So on average, my cases are around 300, 280, 250. And that is, that it's about that number per year for the last, I guess, wow, I'm now on 12 or 13 years. Mm-hmm. And so if I'm getting on average 40 cases a quarter, and my numbers don't go up dramatically, that's 120, 150 a year on average. But may I give an instance of why it is not that, everyday cases are coming in as I close cases, but may I give you an example of why it is not easy to manage a criminal and civil docket. For example, when I started as a trial court judge, the clerk of the court gave me a schedule. The clerk of the court makes the schedule, so judges have 3 weeks on, 3 weeks off to try cases. So for any given calendar year, January to December, when you look at the 3 weeks, I have 106 business days to try 80 criminal cases and 200 and something civil. Or I should say 150 jury civil cases. You cannot fit that number of cases in 106 days. You can't try them. And that is where the efforts of the parties come in. The Department of Justice, the public defenders, the defense bar. So the court cannot manage its docket, or judges can't manage it alone. It takes all kinds of participants to move it, to keep it moving. So I hope that answered your question.
It does. It sounds like it's a very complex undertaking, and I think that's what you wanted to say succinctly, to really show how many cases that you've closed because of one case might take longer than another. So
Absolutely.
you played that role. So it's a very complex situation where you're dealing with human beings, and it's not something that you could just say this is going to fit here for each case, and this is how much time. It will take some time. So I appreciate that. And that was also for the benefit, and said and asked for the benefit of the nominee for the Superior Court, Attorney Renee, so she could also have an appreciation of that, which I'm sure she already does, but it was said for her benefit and asked, and you responded for her benefit. Senator Clifford A. Joseph, you are recognized for your 5 minutes.
Thank you, Madam Chair, and good morning to the...
Good afternoon.
Good afternoon.
Good afternoon, good afternoon. I'm still in the man. I got a phone call. It took me away for a minute, so I'm here now. I'm back in the room. It took me out of the room for a minute, and I'm back here in the room. And again, welcome to the two nominees, and welcome to everybody who is here to represent them as well. And good afternoon to the listening public. Good afternoon to my colleagues as well for being here this afternoon. Honorable Judge Denise, Francois.
Yes, Senator.
You served 2 terms and with the Young administration, and then you got a chance again to serve with no Bornn administration. How will we ensure your decision remain completely independent, especially in a small community where personal and professional relationships are common?
Well, I am required by the Judicial Code, by the oath that I take, to be independent and impartial. I know part of the process, whether you're at the trial court level or at the appellate court level with the VI Supreme Court, the first thing to do is review the case and see whether you have any connection with any of the parties. The Supreme Court has a rule, I believe, that says you have to wait 2 years before you can sit on a case with a former law partner. But you screen cases to see if you know anybody, if I'm related to anybody, and if I've worked with someone in the past, and if the standard really is if there's an appearance of impropriety, then I will recuse myself. Okay. And also you, at the trial level, you can disclose it to the parties. I'll say, so-and-so is my neighbor, but I can still hear the case. Do you have any objection? and the parties have an opportunity to weigh in.
And thank you for your response. And I'll ask the Honorable Renee Andre Esquire the same.
Thank you for that. I agree with what Supreme Court Judicial Nominee Judge Francois has said. We are required to be fair and impartial to all persons that come before the court. And so if there is a conflict, I would disclose it immediately and address it with the parties. And if they're not willing to waive it, then my next step would be to recuse myself.
Okay. And as far as, again, I'll stay with you for a minute. Here in the Bornn, to me, most folks feel, I wouldn't even worry about what most folks feel. I feel personally, a lot of times you listen to other constituents and they're complaining of how the process at the court seems to be dragging slow. As far as you being nominated here, what's your plans of moving your docket?
Oh, thank you for that. So when it comes to moving the docket, we want to ensure that there are timelines in place, right? At the time that a case comes in, that it has a jury trial scheduled, the motions hearing is scheduled, status conferences are scheduled. And so with that, I would do my best to keep to those timelines, those time standards. I would rule in motions as soon as possible to ensure a lot of times the vast majority of cases are resolved in motions practice. And so if I can rule on motions timely, that can bring resolution to a lot of cases that are before the court. So really it's keeping to time standards.
Thank you for your response. Honorable Denise Francois. My question would be, can you describe a time you change your legal position after hearing a opposition argument?
I have had sentencings where I've read the entire file, I've presided over the matter up until the point where a defendant either pled guilty or was convicted. I've read the victim statements, I've read the probation's pre-sentence report, and
Time.
you know what the law says, what the maximum and minimum penalty is. And I have had sentencings where the defense lawyer has brought in witnesses, like character witnesses and other information that have changed my mind on the sentence I was going to impose. In civil cases, I have read I've read motions to reconsider, and I have reconsidered my opinion and granted the motion. It doesn't happen often, but it has happened. I'm hesitant to give specifics, but it has happened. I would say the most dramatic example is at sentencing.
Okay, thank you for your response. Madam Chair, could I ask one more question?
You may proceed to wrap up, Senator.
This is for both of you guys, so you could answer me.
I'll let Attorney Andre go first.
Okay, good. This is an easy one because I just listening to your testimonies, both testimonies, I see for sure that you understand the fabric of our community. So that's what I'd like to know, that you understand the deep fabric of our community that we live in.
Oh, absolutely. Certainly. I was born here, raised here. I live here. My family lives here. I read the newspapers every day. I see what is plaguing our community. Oftentimes, we are also touched by it. And having that understanding allows me to have empathy when people come before me, when persons come before me on the bench. Empathy for their situations, but also the ability for me to sit back and listen to what comes before me fairly and impartially.
Thank you for your response. Judge.
Hi, Senator.
Yes.
So I have brought some of my extended family here, friends, coworkers who have come to support me. I moved back here when I was in 5th grade. I grew up in Lindbergh Bay. I used to take Manasseh bus from Daniel's Variety Store to Hideaway Road when it was 35 cents.
Okay.
And walk to my grandmother's house.
Okay, good.
So I am very familiar with local knowledge and customs and what the VI, what makes up the VI.
Well, thank you both for your responses. And I must say that that particular question came from a family member of yours. It wasn't a question. I made a question out of it.
Oh,
but
okay.
Just explaining who you are. So I'm just
okay.
letting you know they're not here today for whatever reason. They really would have liked to have been here. But after reading it myself, I said, let me just ask it between both of you. But thank you for your response. And thank you, Madam Chair.
And you're welcome, Senator. I do have a question for Attorney Renee, because you talked about ruling. Now, I've asked it of previous judicial nominees whether you would feel comfortable making a ruling from the bench. Certain times, judges, they would feel a little bit reluctant to make a ruling from the bench. What is your perspective on that? Do you believe that you'll feel comfortable making a ruling based on your internal or checklist, your professional checklist from the bench?
Thank you for that, Senator Joseph. And absolutely, there are certain cases, and when I come on the bench for a matter before me, let's say it's a hearing, it's preparation, it's knowing what the parties have already submitted in their motions practice, and reviewing it. I have already spotted the issues, and I'm ready to hear what I need to hear in order to rule from the bench. I take no issue. I have no concern about ruling from the bench in certain cases.
And that would help, I believe, and I understand, with moving the cases forward so that, persons on either party aren't waiting for an order to be issued by the judge. You can give the order and then follow up with the written documentation on the back end.
Absolutely, Your Honor.
Thank you. Thank you so much. It's fine. You can see that you've been practicing. The chair will now recognize the at-large senator, the Honorable Angel Bolques Jr., for your 5 minutes. Senator Bolques, kindly proceed.
Thank you so much, Madam Chair. Good afternoon, Madam Chair. Good afternoon, colleagues. Good afternoon to the listening and viewing audience. Good afternoon, Central staff, and good afternoon to our nominees. Here before us, the Honorable Denise M. Francois for the Supreme Court of the Virgin Islands, and Ms. Renee M. Andre, Esquire, for the Superior Court of the Virgin Islands, along with all of the supporting staff here in the chambers. Good afternoon to everyone. Justice is blind, but her scales are balanced. That is Lady Justice holding the scales and the sword and representing impartiality, ignoring race, creed, or status, while equally weighing evidence and facts. And I believe that that is the onus or the core integral part of the judicial system, or what really runs it. So I wanted to ask a few questions that sort of dealt in that little area there. When it comes to what type of judge or judging style that you have, could you give me one sentence to explain your style as a judge?
Would you like me to go first?
Sure.
My last name starts with an A. I'm accustomed to going first. My judging style on the bench, I would say, would be to approach each case fairly, impartially, and neutrally. That's really all a judge needs to do in order to ensure that justice is served and that parties are fully heard before the court.
Okay. And Judge Francois?
I would say thoughtful and fair.
Thoughtful and fair. Okay. When each of you walk into the courtroom, what do you expect from your attorneys and the litigants? What is one of the biggest expectations that you require from attorneys and litigants when you walk into your courtroom?
I'll go first. I expect preparation. That is how I was raised in the law, and that's what I will expect from anyone that is appearing before me, that they come before the court prepared and ready to move the case forward.
Good afternoon again. I also expect attorneys to be prepared and to be accurate in what they present in their written submissions, because when a judge has to unscramble and figure out what an argument is or what a pleading says, that takes more time. And I would, so getting back to, I'm sorry. So with respect to ruling from the bench, we are required by law, if it is a case without a jury, to give the parties an opportunity to submit facts and findings of fact and conclusions of law. Invariably, the lawyers say they need more time, but you can't rule from the bench right away. They want an opportunity to send in their arguments. And sometimes when lawyers are not prepared and they give a disorganized presentation, you cannot rule right away. You've got to go back to your desk and figure out and organize your thoughts.
1 minute.
Because they were not presented to you in an organized manner. That is not a common problem, but it is a problem that adds to what judges have to do.
So I know that it's been bandied about that, that cases aren't moving as quickly, but it's not just the judge, it's everybody. It's the litigation, it's the attorneys, and to your point, everyone should be prepared. It doesn't always happen that way, I could understand. But before my time expires, I really want to ask, you've authored over 200 memorandums from what I read. And is that correct? Or opinions?
I did, yes, but it's actually more than that. Okay. Because those are the ones that show up on Westlaw or LexisNexis, and my law clerks did it. They went on and you put in the judge's name and it gives you a list. Yeah. But it doesn't show orders that are just as long and detailed as memorandum opinion that you may issue from the bench, or that is not a complete list. For example, I had one case, a lengthy commercial case involving businesses, where in that case alone, I issued over 90 orders and memorandum opinion, and that's in one case.
Okay, and if I may, Madam Chair, please.
You may proceed to wrap up, Senator.
Thank you, Madam Chair. This question is for both of you. What is the one most important change or recommendation that you would want to provide to each of your respective courts in order for it to be more efficient?
To the institution of the Superior Court, or to Attorney Andre?
The court, yes.
To the court.
To the court, yes.
I send emails every day almost. They're tired of hearing from me. I would say training of new employees.
Okay.
I would say training of new employees and renewed training.
Okay.
As the year goes on.
Thank you. That is a difficult one because I have not yet assumed the bench. I hope I will be given that opportunity. But for me, I would like to see that judges are provided with adequate resources in order to do the work that needs to be done. And that includes from having law clerks, the pay for law clerks compared to outside the Virgin Islands. That becomes a big part of the judges' work, relying on their law clerks to be able to assist with researching and drafting documents. And so we want to entice the best and brightest to come here, knowing that we have a high cost of living, and a lot of them will have to get homes and cars and everything here because you can't drive that across the sea. And so just resources.
Resources, okay. Thank you so much for your responses, and I look forward to voting at the appropriate time. Thank you so much, Madam Chair.
And thank you, Senator Bolques, for your line of questioning. Before I proceed to Senator Alma Francis Heiliger for her 5 minutes, there's this, because we've encountered it, there's this really burning issue I have. And you are saying both that you will remain neutral. Mm-hmm. Now, we have 3 branches of government. This is the first, the legislative. Then we go to the executive, and the judicial is the third. What is your understanding? Because outside of, you're supposed to remain blind, and the at-large senator mentioned it, because you're supposed to be able to separate from the political and personal influences that are surrounding. And this is a very small community, very small. Everybody knows everybody. I see people here who I know who are a part of your family, and I wasn't even aware that they were part of your family. But it is a very small. How do you see, or do you interpret the separation of power and the role? Because even now we have this big fight that is going on nationally with the executive branch, not so much the legislative, but the judicial has stepped in major ways to make rulings, in checking the powers of both this branch as well as the executive branch. How do you see your role? Let's start first with you, nominee Francois.
My role is to follow the law, and the law is that the branches are separate and co-equal. That's my job, to follow the law and apply it in the cases that are before me. If a matter comes up involving the legislature or the executive branch, and actually more on a daily basis, agencies of the executive branch, I apply the law and I follow my oath. I apply it impartially and without regard to somebody's station in life or their position.
And you, Attorney Andre?
I would agree with that. I mean, the surest way to carry out the duties of a judge is to be fair and impartial and to apply the law to the facts before the court.
What about when there are some type of ambiguity? Ambiguity. Thank you so much. Ambiguity in the law. The law is not clear. So it leaves to some interpretation. What is your philosophy and how you would approach that? Let's start with you, Attorney Andre.
Thank you. If the law is clear, it is applied, right? Black letter law. If there's ambiguity, I do research and I look for precedent. We call it stare decisis. I look for precedent and I would analyze and apply that precedent and make my ruling.
Thank you. And that's what I was hoping you would say, and you did say. Judge Francois?
Yes, Senator. So you had talked about ambiguities. When there's ambiguities, there are legal principles that we follow, one of which is statutory principles of statutory construction. You look to other jurisdictions that have similar laws or similar language, but the judges follow the principles of statutory construction.
And what do you mean by statutory construction? Just to break it down for us.
It's a legal term of art that, for example, you give words their basic meaning. Like if it's ambiguous, you start with the dictionary. You start with Black's Law Dictionary. If there's no cases on it, what's the everyday meaning of this word? And if Merriam-Webster doesn't have it and Oxford doesn't have it, and then Black's Law Dictionary doesn't have it, then you go to what courts in other jurisdictions, how they've looked at it, beginning with other jurisdictions that have the as close as possible language.
Okay, very good.
Those are examples.
Very good. Thank you for that in-depth explanation. And I'm sure Attorney Andre is well aware because she also mentioned she looks at the statute and precedent. Senator Frances Heiliger, you're recognized for your 5 minutes.
Thank you. Thank you so much. Good day to my colleagues. Good day to the people of the territory. Good day to the testifiers. Welcome everyone here in the chambers and staff. Honorable Denise Francois, my first set of questions I want to ask has to do with, over the years, how has your judicial philosophy evolved? I know it's one thing when you're coming in compared to being there over the years. How has it evolved for you?
What is coming to my mind right now is that I believe I have become more skeptical and less naive.
Okay.
I give everybody the benefit of the doubt, but, you know, experience teaches you things.
Good. Well, I like that response because if you
I'm glad you do.
I also wanted to talk about, you know that I was looking at some numbers, even cases here locally, nationally, and a lot of cases that end up in a court are against the government. And I was like, wait a minute, that's an interesting number when I was looking at different cases. And I said, how do you as a judge, knowing that by technicality you're still part of the government, and how do you handle cases like that? Because I've heard things of like undue pressure, certain things being pushed in particular directions. And if in any instance, let's say someone or a situation came about where they were suggesting you as a judge go in a particular direction, how do you handle that and put an end to those type of things?
Well, first of all, I want to begin by saying anybody who knows me knows that I am not going to be swayed or influenced to do anything that's improper. It's just not going to happen. And there are rules in place that prohibit what we call ex parte communications. I enforce that. So that means if somebody is a party in front of me, they're not going to call me up at home or at the court and say, I want you to do something this way. They're not going to send me an email saying, they want me to rule in a particular way. That they're, you know, my staff is my secretary and law clerks. They are an extension of me, so they are not taking any calls from somebody that would be improper. With respect to government being a party, when the government's a party, you say, for example, in a civil case where the government is trying to collect rent, or if a tenant is suing the government and saying, you know, this is a bad bad premises, you need to let me out, or something like that. It's just as if they were people. I treat them fairly. And I have to say that in cases before me where the government is a agency, where the government agency is a litigant, the government employees do an outstanding job representing their individual agencies. They do very good with what they've got to work with, bad conditions, or I'm always impressed by government employees that come to court and testify. They are amazing. And they represent and defend their agencies as vigorously as the other side is going after their agency.
Understood. Appreciate it. I want to have a chance to speak to Ms. Attorney Andre. You were a little different today because I saw the name and I was reading all this stuff and I was like, it's only when I saw the face. I said, wait a minute. And I remember when I realized it was you, I said, oh God, I'm old. And I say this because her mom and my mom were very, very close friends. So we were always around each other when we were younger. And I was so tickled at the fact that, and we also grew up in church together, Church of God of Prophecy, 100-year centennial this year. So I'm gonna toss that out there.
Time.
But I was like, I didn't see this for you. I did not see lawyer. And I was so tickled when I realized it was you. And I think this is really good. But what I want to ask you directly, what do you think has prepared you? Now, I looked at some of your information, family law, different things that you focus on. What do you think has prepared you to take on this position?
Thank you for that, Senator Francis. Everything that I have done throughout my professional career has prepared me to take this office. From moot court in high school, my judicial clerkship, which I must say was a true experience in the law. I handled trial matters and appellate matters because at the time I was clerking, the district court served as the appellate court for the Virgin Islands. And so I had the opportunity to do both trial and appellate work. And my court appointments, my indigent defense panel cases, my family law cases, my business cases, my, everything that I've touched throughout my career has prepared me for this. And just my temperament as well.
Okay.
The way I approach things, the way that I always give people an opportunity to be heard, all of that has prepared me.
Good. We often talk about the backlog in the court system. How do you think you'll be able to tackle or handle that with efficiency? Because, we don't want it get to the point like you come back up for renewal and it's like, oh, I got 300 cases. I'm trying to keep up. And I'm not saying we might not get there because we probably need more judges. But my thought process going in, how do you think you will be able to handle that with efficiency?
Backlog cannot be set at the foot of any one thing. There are several things that are moving together that can cause backlog. My role as a judge is to ensure that the parties get cases to be trial ready. That does not mean that it will proceed to trial, but they need to be trial ready and to move it forward to ensure the parties are filing their motions timely. And if they do not, then I will issue an order as to why they have not filed the motions within the deadline. Ensuring the parties are doing what the court has said in its orders. And making timelines for myself, touching my cases, ensuring that I am fully aware of the docket of cases before me and touching them on a regular basis to move them forward.
Excellent. And this, Oh, may I ask my final question? Thank you.
Yes, you may proceed to asking your final question. Your time was called.
I
would
appreciate
allow
it.
it. Thank you.
My final question I want to ask, we're all human beings. Even sitting here, sometimes in the legislature, we put things out and we have to go pull it back and redo it just to fix it. If there ever is a situation that either of you realize that some legal error was made, how would you guys handle that?
I issue an errata order.
Okay. Okay.
You mean if I make a legal error?
Yes.
Yes, I will. I'll issue an order. XYZ has to be corrected, and the parties don't waste any time letting you know when you've made an error.
Agreed. I would disclose it and take steps to rectify that issue.
Okay, thank you. My time is called. I think both of you are well equipped to go to the positions that you are suited for. And thank you for the time. And I definitely will support both of your nominations.
Thank you, Senator.
Thank you.
Thank you so much, Senator Francis Heiliger. At this time, the chair would like to recognize the presence of the committee vice chair, Senator Kenneth Gittins, who is joining us from the Fritz Lewetz Conference Room in St. Croix. Senator Gittins, thank you for being there and holding it down in St. Croix for us. Thank you so kindly. Now the chair will proceed with recognizing Senator Ray Fonseca for your 5 minutes. Kindly proceed, Senator Fonseca, for your 5 minutes.
Thank you so kindly, Madam Chair, and good afternoon to the viewing and listening audience, colleagues, and the full panel of family and friends, and of course, distinguished Judge Francois and also Attorney Renee. Welcome to the Earl B. Otley Chambers. I gotta just divert one quickly. You mentioned Alton Adams, and it's interesting how things touch because I was an art student in high school and I won the Alton Adams Scholarship. So Mr. Alton Adams was responsible for paying for my university tuition. So I'm always grateful. And of course, with Judge Francois, most of my career for 22 years, I was a student of Conrad Ricky Francois, who I've learned a whole lot from and I admire greatly. So I wanted to start with you, Attorney Renee. So you're a partner in a law firm handling criminal and civil cases, but now you're going from attorney to a judge. So let's just say you previously took a position Y as an advocate. And how would your role change now that you may be setting state precedent?
If I understand your question, are you asking if I took a position as a
Advocate. In other words, as an attorney, you're supporting a client. You took a certain position. Now in the role as a judge, how would your positions change as a sitting judge?
So as an attorney, I have an ethical duty to represent my client and represent my client zealously, utilizing the law and the facts to bring a favorable outcome for my client. As a judge, my duty would be to the process to ensure that it's fair and impartial. And so I don't see an issue with that transition.
Okay.
It's still an ethical duty. It's just that my duty is now to the process as opposed to any individual client.
Okay, one follow-up question. So how would you approach interpreting cases or statutes when the language is ambiguous, and what role, if any, should legislative intent play in your decisions?
Thank you for that, Senator Fonseca. So if there is ambiguity in the law, I will look to precedents. I know Judge Francois indicated statutory construction, and that is definitely something that we would do as judges, is looking at the plain letter of the law and seeing what definitions come from that. legislative intent can be possible, but it would need to be written. I cannot assume the legislative intent. I would need to see it written so I can understand what was in the minds of the legislature at the time that they passed that law. But really, it's looking at precedent to see how was this issue dealt with previously, whether it's another judge in the court or a judge from a different jurisdiction that had similar language.
Okay, thank you. And now I'll go to Judge Renee, Denise M. Renee. I mean, Denise M. Francois.
That's
Getting a
okay,
little
Senator.
confused.
My sister's middle name is Renee.
Yes, yes. Okay, so continuing on the line of precedent, as the Supreme Court, first, we're in a constitutional convention. We don't have a constitution, but I wanted you to give me under what circumstance should the Supreme Court overturn its own precedent?
I think that is getting into territory where I should not comment on, because there may come, if I am fortunate enough to be approved,
Okay.
and if I go to the VI Supreme Court, and if such an issue arises, at oral argument, some lawyer may show up and said, but when you were answering Senator Fonseca's question,
Okay.
you said these were the circumstances.
Well, let me rephrase the question here. So, what's the proper boundary then between judicial interpretation and judicial policy making?
Well, it depends what your philosophy is. There are people that say judges should not make law or policy. Judges should stick with reviewing, applying the law to the facts. On an appellate level, it is you're reviewing the case to see whether something happened at the trial court level that should be reversed because somebody's appealing a particular decision that they didn't like. I don't think there's a simple answer. It's going to vary from case to case, but
And so
it's not that simple.
It
I'm
depends.
sorry.
Yes, I understand. And I just wanted to ask one final question, Madam Chair, if I may.
You may proceed to wrap up, Senator.
Yes. So discussed a case where you've ruled, advocated in a way that was unpopular with your peers.
My peers meaning other judges?
On the bench, yes.
I cannot think of a specific one, but Superior Court judges do not have to follow what other Superior Court judges may say. We have to follow what the VI Supreme Court says. But I can't think of one, and, my colleagues would never say, I didn't like that.
Okay.
It's
Basically, it's non-interference then.
yes. Now, I'll tell you, I will talk to my colleagues and say, have you had a situation like this? Or we definitely talk to each other. And I will call up colleagues, other judges, and ask them, what do you think about this? But it would be highly unusual. The closest you get to that is somebody would say, I wouldn't have done it like that.
Mm-hmm. Okay. And I've looked at the model code, and I think that's a good draft for the legislature for our own rules also. So thank you so kindly, and I'm definitely in support of both of your nominations. Thank you, Madam Chair, for the time.
And thank you so much, Senator Fonseca. The chair will now recognize Senator Milton Potter, Senate President, for your 5 minutes. Kindly proceed, Senator Potter.
Thank you very much, Madam Chair. Good afternoon, colleagues. And a special good afternoon to the Honorable Denise M. Francois, as well as Attorney Renee M. Andre Esquire. I want to start with you, Attorney Andre. First of all, thank you very much for accepting to take this very critical, this very important position here in our community. The job of a Superior Court judge is awesome. The responsibility that falls on your shoulder is definitely an awesome one. So I want to thank you for stepping up to the challenge. You've practiced primarily on one side of the bar as an advocate. How will you manage the psychological and professional transition from passionate advocate to neutral arbiter, particularly in case types where you've had strong personal investment?
Oh, thank you, Senator Potter. That question packed a lot. I'm going to start with one phrase that you said. You said strong personal investments. Yes, the positions that you can take as an attorney can be seen as personal, but really what I am doing is advocating on behalf of my client zealously to bring forth a favorable outcome. And so I don't see it as a big psychological change. The way I have approached all of my matters is with an open mind. A great person once told me, to be sure that you are correct, you have to try and prove yourself wrong. And so that allows you to see the other side. And I've always approached all my matters with an open mind to see both sides of an argument. And that's the same thing that I will take before the bench. And again, as I indicated, it's now as an attorney, it's a duty to a client. On the bench is a duty to the process and ensuring that justice is served.
I appreciate your response. Now, you state that you're not influenced by status or external pressures. Can you describe a specific situation where you were faced with a pressure situation from a client, a colleague, or otherwise, and how you navigated it?
I'm thinking of a way to answer you without disclosing any client confidential matters. Often, someone is going to disagree with the position that you take. And so I'm not making a decision to satisfy anyone. What I am doing is looking at the law and the facts and applying the law to the facts. And that's the way I approach everything. I have had instances where I did not agree with a position of my partner in the firm. And that did not stop me from proceeding the way that I thought was the correct way to proceed.
I respect and I appreciate your response. Now, there is a perception, and maybe it's more than a perception, in the community that the wheels of justice at the Superior Court turns very slowly, meaning the backlogs, and it just seems as someone who has to deal with navigating the judicial system, it seems like it takes forever for cases to be heard, to be resolved, to be disposed of. In your view, and I know you're not on the bench as yet, but you're an attorney, bar attorney, interacting with the court on a regular basis. Is there merit to the perception out there that the wheels of justice seems to turn a lot slower than it should here at the Superior Court?
I would say that there is some merit. A lot of times, the community, the public at large, believes that once they read about an arrest in the paper, that the next week or the next month, the case would be resolved. And that is just not the case. Everyone appearing before the court is entitled to due process. And so that takes time to ensure that they get a fair opportunity to be heard. And so Well, there may be some merit. There may be some cases that do not proceed as quickly for whatever reasons. Sometimes parties change their counsel. Sometimes counsel may get sick and need a continuance. That can happen. For the most part, I think judges are doing their best to move cases forward.
Okay. Thanks for your response. Now, Judge Francois, the Supreme Court's work is fundamentally different from trial court. No witnesses, no juries, no live evidence, primarily written briefs and oral argument. How have your 4 appearances as a designated justice and your appellate panel work specifically prepared you for that shift? And what gaps do you believe you still need to fill?
When I served on those appellate cases as a designated justice, I was, you appear for oral argument, you sit with the other 2 justices, you hear the argument. Before that, you read and review the written submissions, the record from the lower court, and what I saw for the first time was the internal conference between the justices when they meet to discuss and put forward their various views on a particular issue. So as a lawyer appearing before appellate courts and then as a trial judge reading what comes back, because most of the cases that we read are from the appellate level, or the ones that are controlling. So reading them for years, for decades, and then participating and seeing the internal, what they call the conference, and then reviewing the drafts that are circulated, I would say those are the 2 things that prepared me, in addition to years as a practicing attorney and as a trial court
Thank you.
judge.
If I may ask you both to weigh in on this, and I was just reading an article maybe a day or 2 ago, and they were talking about a Scandinavian prison model. I don't know if that's something that's familiar to you. It wasn't familiar to me at all. Particularly practiced in Norway, Sweden, and Denmark, and it's built on one core belief that the purpose of prison is rehabilitation and not punishment. So the key principles, normality, which life inside a prison should resemble life outside as closely as possible. Inmates have private rooms, cook their own meals, wear their own clothes, etc. Humanity, prisoners are treated with dignity. Guards are trained more like social workers than enforcers, etc. And reintegration focus. The entire system is designed around the question, who do we want this person to be when they leave? What are your thoughts on that?
You want me to go first?
I'll let you answer on the chair's time. Thank you very much in advance for your response.
I have read that. I have read articles about it. It may vary a bit by bit from country. I believe it was Sweden where a man had gone during the summer to an island and basically done a mass shooting. And even in light of that, he was not sentenced to life. He's eventually going to get out. So, those nations have chosen to focus on rehabilitation. I think because they're smaller, they can, to use Senator Joseph's term, like pivot easier. They're more homogenous. But, in the United States, our rehabilitation is a component of the criminal justice system, and it's not just punishment. There's punishment, there is rehabilitation. The goals of it's punishment for a crime, and like to send an example, deterrence. So, but we are limited in what we can do in the rehabilitation, and that is something we should probably look at, because a lot of times the conventional wisdom is that somebody goes in and they serve a lot of time and they come out worse. But by the same token, there are people that go in and they come out and they've had time to think about things. They've turned their lives around. There are good stories. There are happy endings of people being punished and going to jail for committing crimes. But that, you know, for the Virgin Islands, that would be a wonderful thing, you know, if we had the money to do something like that. I don't see that as something not welcome. But then there's also the issue of, I think what comes with that is a lot of counseling and therapy. It's not just, here's your nice room. There is a big counseling component to that sort of system.
Thank you for that question, Senator Potter. I don't believe that you have to do separately, that you have to either focus on rehabilitation or punishment. They go hand in hand. And the way the law is set up, it tells you what the penalties are for the types of crimes. And so you have the ability as a judge to take into consideration external factors in fashioning a sentence for someone that represents what the statute requires, as well as providing some rehabilitation for the defendants. But I also agree with Judge Francois that the resources to put forth those policies needs to be in place as well.
Yeah. Thank you very much for your responses, testifiers. And at the appropriate time, I plan to vote in the affirmative for both of your confirmations.
Thank you so much, Mr. President. You know, we try to be very accommodating here for this committee meeting, especially, and knowing that we have some nominees in front of us. At this time, the chair would like to recognize our vice chair, Senator Kenneth Gittins, for your 5 minutes.
Thank you, Madam Chair, and good afternoon to all. I first want to thank the nominees for their willingness to serve and to continue serving as well. Our first nominee is no stranger to the system and is in fact a seasoned jurist, now being nominated for elevation to the higher courts. And so your record basically for me provides us, or this body, with substantial foundation that or to which you have proven yourself at the Superior Court level. So I look forward to having this discussion with you. And to the second nominee, you're getting your feet wet. Your nomination marks an important transition for you at this time, wherein as an attorney, you will now transition from being an advocate to now an arbiter. So I congratulate both of you and thank you again for your willingness to serve. Now, my good friend, the Honorable Francois, how are you today?
Fine, thank you, Senator.
I am great. I am blessed. Having served as a trial judge within the Superior Court of the Virgin Islands, how would you adjust your approach now to respect the appropriate standard of review, particularly when assessing factual findings versus legal conclusions from the Superior Court of the Virgin Islands, where you'll be transitioning from.
I'm sorry, how will I what?
So how would you adjust your approach to respect the appropriate standard of review, particularly when assessing factual findings versus legal conclusions from the Superior Court?
Right now, on cases that I have that are on appeal from government agencies and from the Magistrate Division, I already have to identify the appropriate standard of review, whether it's plenary for a legal issue or whether it's, say, a clear error of law for a factual issue. So I'm already doing that. And in addition, even when it is not an appellate issue, when you address a matter in court or a motion, you've got to identify the appropriate standard of, the applicable legal standard and render your decision by applying that legal standard or as permitted by the legal standard. So I really don't see much of an adjustment or transition that I need to do. You know, we all day, every day, the judges read cases that are handed down by the VI Supreme Court and other appellate level courts that guide us in our decisions. So I don't see much of a transition.
Great.
1 minute.
Great. That's probably similar to my good friend Justice Swan, because he continues to read. He doesn't even want to see the computer. I see him with his books, his documents, and everything still going. But that's good. Let me just stay pointed so I can get this, because the time is running so fast. So would your experience on the trial bench inform your view of the Supreme Court's role in maintaining public confidence, ensuring judicial independence, and providing guidance to the lower courts?
One is the appellate arguments are, I think, live streamed. They are also open to the public. Another way would be to, keep in mind I'd be one of 5, when opinions are issued that they are understandable to members of the public. I think judges tend to get caught up in just writing for lawyers, but I think language could help explain things, and just being as transparent as possible.
All right, thank you. Let me run over to Attorney Andre quickly. How are you doing today, ma'am?
I'm doing well. How about yourself?
I am blessed. Thank you for asking. So the Superior Court handles a heavy and diverse docket. What specific strategies would you use to manage caseload efficiently while ensuring litigants, especially those without counsel, receive a fair opportunity to be heard?
Thank you for that, Senator Giddens. That was a lot to unpack as well. So in terms of the heavy caseload and moving it, time management, setting deadlines, keeping to those deadlines, in terms of pro se individuals, parties who are not represented by counsel, ensuring that they have a fair and full opportunity to be heard, is to speak plainly. Make sure that the information that is being given to the pro se litigant is in plain language, that they completely understand what is going on in the courtroom, pro se litigants should be given some leniency because they are not attorneys. They did not go through that rigorous program to practice law. However, that would not be at the expense of fairness to the opposing party, but I do support measures that would provide pro se litigants with resources to move their cases forward.
So thank you for that response. Madam Chair, I know that time was called, but can I wrap up?
You may proceed, Mr. Vice Chair. You may proceed.
Okay. So thank you. So following up there, so I understand that cases are continued and whatnot, but what I want to be assured of is that you will have a team that will follow up on these continuations, because I know that there are legitimate reasons for continuance of cases, but at times we tend to get so bogged down that we don't even remember to go back and meet those deadlines. So I just want that assurance from you that your caseload will move forward.
Oh, absolutely. And, you know, even if a continuance is granted, my belief is that it should not be granted without a new date.
Thank you.
Put in protocols
Thank
for
you
the
for
parties
that.
to
You
follow
don't
up.
even have to go no further. Thank
Okay.
you for that. You don't even have to go any further. You know, I was the freshman senator that introduced the single court, the court unification, and I mean, I had a run for my money with this, but we had a double head serpent that we needed to make sure that we address, and now we have the unified system. And in the unified system, one of the things that we also did was made sure that they had the magistrate court, the magistrate judges in there so that we can address a lot of these case loads. But we're seeing still where there are some backlogs. Lastly, how do you approach interpreting Virgin Islands statutes and precedent when they are silent or evolving? And what role should persuasive authority from other jurisdictions play in your analysis?
Thank you for that question, Senator Giddens. As an attorney, the Supreme Court of the Virgin Islands has provided a structure for the court to determine cases where we may not have precedent. And anyone who's an attorney know that that's called the Banks analysis. And that is what I would follow. And the Banks analysis, that will take me to looking at precedent from other jurisdictions and how that would affect the Virgin Islands and what is the best practice going forward. It is not for me to create new law, just to interpret the law and apply the law to the facts. And if a party doesn't agree, I guess they will go up and appeal.
Great. And just lastly, because I was looking at the news and reading through some stuff, and I saw, you know, in recent months, we've read about AI-generated research being used in courtrooms. And I'm just wondering, how would both of you address this to ensure that information that's presented to you by attorneys coming into your courtroom are not fictional?
You want me to go first?
Sure.
Yeah, anyone.
All right. So the first thing I do and my law clerks do is when we receive a pleading, we check the cases. And I don't think we've had any, and the lawyers know I check the cases because they get orders that say, this case doesn't say what you said it did, or this case that you used in your argument, when you read the whole case, it doesn't support your position ultimately. So the lawyers know that we check it. I do not think that we have had any blatant examples of AI hallucinations where the lawyers will submit a brief that they have had their AI legal research program generate without them checking. What has happened, though, with LexisNexis and Westlaw and online legal research is that pleadings are now very case intensive, and the arguments are, I would say, more complex. This has been over, say, the last 10 or 15 years, so that adds to what judges have to address. So, for example, it is not unusual, and I'm warning Attorney Andre, to get a motion for summary judgment where just the motion and its 20-page brief and the exhibits are 500 pages. That is just the one, that's just the starter. And then the other side gets to file an opposition, and then the party who filed the motion gets to file a reply. And then the other side says, well, we need to say something else, and then they'll file a motion for permission to do a surreply. So I digress. We check the cases. Whatever a lawyer files, we check it.
So I see that you've been doing your due diligence. Are there any actual tools there for you to check that at the Superior Court level?
Yes.
Do you have any tools?
Yes, we have law clerks. We use Westlaw and we use LexisNexis. You take whatever the case citation is that a lawyer has in their brief, you plug it into the computer, and the case should pop up. And sometimes you got to read the whole case to find that one sentence that they rely on. But we check.
Definitely. Thank you. Thank you so much. Attorney Andre, I don't think it'll be fair for me to ask you that. But like the judge says, be on the lookout and just make sure you do your due diligence. Again, congratulations to both of you for being nominated to serve in the position that you were nominated for. And thank you again for your willingness to continue serving the people of your community.
Thank you, Senator.
Thank you.
Madam. Thank you, Madam Chair.
Thank you so much, Mr. Vice Chair. I really want to commend the governor for sending out two very qualified nominees in this body so that we could consider and vet you properly. I really want to also thank you both, ladies, for saying yes. You know, we're finding a lot of the times that we have a little bit of a challenge in finding good, qualified, dedicated individuals who understand the work is not necessarily when you're working in public sector to receive a high pay, but to actually do the work for our people on behalf of our taxpayers. And our taxpayers come from all walks of life. And I typically ask one leading question, and that is, for me, access to justice. Access to justice is a major issue for me because we have a large amount of people who are in poverty. And I know, Attorney Andre, you mentioned pro se litigants, and those are people who are representing themselves because for whatever reasons they may not be able to afford to pay for an attorney to represent them. So I will start out with you, Attorney Andre. What steps would you take to ensure that pro se litigants are able to receive a fair hearing in your courtroom?
Thank you, Chairwoman Joseph. Pro se litigants, we encounter them often. As you indicated, it may be financial. It may be that they just feel that they are the best person to put forth their case. And so they are not fully aware of the legal standards or the procedures. And as a judge, I would ensure that I'm using plain language within my courtroom so that they can fully understand the procedures. I also support self-help pamphlets, something that explains the different stages of the case and what to expect when you come to it, evidentiary objections, providing those before you get to the courtroom so that they can prepare themselves. Because while we have to ensure that they have full access to justice, we also have to balance that against infringing on the rights of the opposing party. And so a lot of it should come pre-trial, before they enter the courtroom, that they have these self-help documents that they can review and prepare themselves with.
What about utilizing someone who is barred to support them? Do you think that could also play a factor in this pro se litigant's ability to be able to receive the guidance real time so that they are represented well?
Absolutely. And as I appear before you today, I am one of those attorneys that was contacted directly to assist a pro se litigant in a civil matter before the court.
Thank you. I know I was going on there. I was wondering when you were going to talk about your experience in doing that. And you, Judge Francois, you're a sitting judge. I'm sure you may have encountered it during your 12, almost 13 years on the bench. But kindly indicate for us, how have you worked with pro se litigants in the past, and what you plan to do going forward?
First, it is the policy of the Virgin Islands court system or the judges to liberally construe and give the benefit of the doubt to written submissions by litigants who are not represented by legal counsel. So we really go out of our way and bend over backwards, which includes trying to figure out what their arguments are. But this is a perfect example or perfect opportunity for me to big up Attorney Andre, because she is one of the, I would say, 5% of the bar that I can call and say, look, I've got this person, they're being sued, they need a lawyer. Can you handle it? And Attorney Andre said, I'll check. Yes. Like, she doesn't hem and haw. She says yes. And she says, let me check for conflicts. So without hesitation, there are some lawyers, there's a short list of lawyers I call when a pro se litigant is being railroaded, like being sued, and they cannot afford a lawyer to defend them. And there are lawyers that I will call and say, can you help them? It's not as many as should, because all attorneys, practicing attorneys, should do a certain amount of pro bono work, but they don't. And Attorney Andre does more than her fair share of assistance of pro se litigants. So, but once she's in, they're no longer pro se. But so, number one, the judges themselves assist the pro se litigants. The clerks assist them. And our legal jurisprudence says that we should. And the fourth way is we will find a lawyer to help them if they want that help.
Okay, thank you so much for your responses. I do have one final burning question, and I think this would really round out the whole vetting process for both of you. And if you could be succinct, what is the one specific change you would like to seek, to implement, actually, in the court you are joining to improve the efficiency and access to justice? Judge Francois, you first.
I really cannot think of one. It's a little different with the appellate level, but one would be to probably do what I do now and to find an attorney to help someone file their brief. You know, it's very it's very difficult for a pro se litigant to, you know, follow the technical rules of uploading a pleading into the system, you know, to a system, filing it manually. But that would be one way to find an attorney to assist them. I have to say, a lot of times, and I don't know how to solve this problem, there are pro se litigants who have lawyers ghostwriting for them. And that is problematic because the lawyer who's doing the ghostwriting cannot be held responsible for what they write. So if a lawyer files a pleading with the court, when they sign that pleading and file it with the court, they are certifying that they've checked the law, that they're not saying anything that is false or misleading, that they've included the most current and updated law, and any law that is adverse to their possession. And if you make an argument that is more than improper, we call that a Rule 11 violation, where if they misrepresent something. The problem is that when pro se litigants have, say, a cause or case or claim that a lawyer will not take, but a lawyer will ghostwrite for them, that creates a whole different set of problems.
Understood, understood. And you, Attorney Andre, what would be that one specific change you would like to seek?
I would like to see form documents that pro se litigants can utilize, whether it's to file their cases or even for motions practice. That will assist them in basically organizing their thoughts and make it easier for the court to discern what their issue is and what they're asking for.
And I like that because I had some research. I had a constituent who came to me. They wanted to do an adult adoption. And the court didn't have any forms to complete that. And this is something I think may be a very simple thing. And our local courts didn't have it, but New York had a form that you just populate and complete, and you could start the process. And I think that is very much where we want to do, especially when we're looking at access to justice and dealing with indigent population. And so I think you are on the right target to develop those forms, put them up on the website, and persons can come and just complete them and submit them to the court. That would definitely help a lot of our community who are indigent or just want to be able to move along something that is maybe a legal matter. Thank you, ladies, for your candid and well thought out answers and responses to my colleagues. Do I hear? No, sorry, one moment. We are now going to give you an opportunity to present some closing remarks. We'll start with you, Judge Francois. 30 seconds. 30 seconds.
I just want to thank everyone. Thank you for your well thought out questions and your attention. And I appreciate this opportunity. And with respect to the family court, I think that Judge Melanie Turnbull is spearheading the campaign to get more forms on the court's website with respect to family court.
That's
So
very good.
she's made that a priority.
That's excellent. I was wondering why it hadn't happened many years ago, but I'm glad that someone is taking it and making it a priority. Attorney Andre?
Thank you. I just want to say thank you to this body for giving me the opportunity to appear before you today, and to thank Governor Bryan once again for his nomination. I ask for your favorable recommendation today, but before I close, I just want to take the opportunity to acknowledge our friends and family that are sitting in the audience and thank them for their support. You may not be aware, but a lot of the persons in here today, both Judge Francois and I are sharing them. And so I just wanted to extend our thanks for their support, as we couldn't be who we are without them.
Well, I knew a little bit about that. Judge Francois revealed to me that your aunt is Miss late Conrad Francois II, right? Wife.
That is
Yes,
correct.
right.
Yes.
And I wasn't aware of that, and you didn't reveal that, but he was one of my mentors, and I knew him well, and he guided me along. So I really am familiar with some of the overlapping in the relationships. Do I hear a motion? Senate President Milton
Yes.
E. Potter, you are recognized for your motion.
Madam Chair.
Media,
Thank
try
you.
again.
Thank
Try-
you very much, Madam Chair. You hear me?
Yes, I'm hearing you well. Kindly proceed with your motion, Senator Potter.
Madam Chair, I move that the Honorable Denise M. Francois, the Governor's nominee as Justice to the Supreme Court of the Virgin Islands, be favorably voted upon by the Committee on Rules and Judiciary and forwarded to the full body for further consideration and action. I so move.
Second.
The motion has been properly made by Senator Potter and seconded by Senator Lewis, Gittins, and Francis Heiliger to favorably approve the governor's nominee, the Honorable Denise M. Francois, as Justice for the Supreme Court of the Virgin Islands. Roll call on the motion.
Senator Angel L. Bolques Jr. Senator Bolques Jr., yay. Senator Kenneth L. Gittins.
Yes.
Senator Gittins, yay. Senator Alma Francis Heiliger. Yes. Senator Francis Heiliger, yay. Senator Carla J. Joseph.
Yes.
Senator Joseph, yay. Senator Clifford A. Joseph Sr. Yes. Senator Joseph Sr., yay. Senator Avery L. Lewis. Yes. Senator Lewis, yay. Senator Milton E. Potter.
Yes.
Senator Potter, yay. Madam Chair, you have 7 yeas.
Thank you, Madam Clerk. The Honorable Denise M. Francois, the Governor's nominee as Justice to the Supreme Court of the Virgin Islands, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. Now you could applause. Now you could applause. Okay, die down now. We're still doing the people's business. Senator Avery Lewis, you are recognized for your motion.
Thank you. Thank you, Madam Chair. Madam Chair, I move that the Governor's nominee, Ms. Renee M. Andre Esquire, for Judge of the Supreme Court, Superior Court of the Virgin Island Division of the St. Thomas St. John, be voted upon favorably in this committee, Rules and Judiciary, and forwarded to the full body favorably for further vetting and consideration. I so move.
Thank you. The motion has been properly made by Senator Avery Lewis and seconded by Senator Alma Francis Heiliger, Senator Clifford Joseph, Senator Milton Potter, to favorably vote upon the Governor's nominee, Renee M. Andre Esquire, Judge for the Superior Court of the Virgin Islands Division of St. Thomas and St. John. Roll call on the motion.
Senator Angel L. Bolques Jr. Senator Bolques Jr., yay. Senator Kenneth L. Gittens.
Yes.
Senator Gittens, yay. Senator Alma Francis Heiliger. Yes. Senator Francis Heiliger, yay. Senator Carla J. Joseph.
Yes.
Senator Carla Joseph, yay. Senator Clifford A. Joseph Sr. Yes. Senator Joseph Sr., yay. Senator Senator Avery L. Lewis.
Yes.
Senator Lewis, yay. Senator Milton E. Potter. Yes. Senator Potter, yay. Madam Chair, you have 7 yeas.
Thank you, Madam Clerk. The nomination of Miss Renee M., the motion for Miss Renee M. Andre Esquire, the governor's nominee for Judge of the Superior Court of the Virgin Islands, Division of St. Thomas and St. John, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. At this time, the committee will stand in recess for 5 minutes. And we are back on the record. Madam Clerk, kindly proceed with reading Block 2 of today's agenda into the record.
Block 2, Bill number 36-0194, a resolution urging the United States Congress and the Office of the United States Trade Representative to expand and modernize the Caribbean Basin Initiative, CBI, to further support economic growth and development in the Virgin Islands and wider Caribbean region. Proposed by Senator Angel L. Bolques Jr., sponsored by Senator Carla J. Joseph, and co-sponsored by Senator Hubert L. Frederick. The invited testifier is Mr. David Bornn, Esquire, resident. Madam Chair, this ends the reading of Block 2 of today's agenda.
Thank you so much, Madam Clerk. Who speaks on behalf of Bill number 36-0194? Senator Bolques, kindly proceed.
Thank you, Madam Chair. Madam Chair and colleagues and members of the public, today I rise again since this bill has been heard in January 2025 to present Bill number 36-0194, a measure that is not just about modernizing a trade policy, but also positioning the Virgin Islands for long-term economic strength, regional leadership, and global competitiveness. The Virgin Islands stands in a unique position that no other jurisdiction can replicate within the Caribbean. We are both part of the United States of America and deeply connected to our Caribbean region. This dual identity is not just a limitation, it is our greatest economic advantage. This bill recognizes that same reality and seeks to actually fully activate it. Since 1983, the Caribbean Basin Initiative has supported economic development across the region through preferential access with the United States market. However, the global economy has changed and our current framework has not kept up with the pace. While other nations adapt and expand into digital trade, advanced manufacturing, and energy innovation, the Virgin Islands risks being left behind if we do not act with urgency. The legislation calls for the modernization and reauthorization of the CBI before its scheduled expiration in 2030, ensuring that the Virgin Islands is not just included, but recognized as a strategic stakeholder in its future. That makes this effort critical and very simple. We are uniquely positioned to serve as a transshipment hub, a center for substantial transformation of goods, and a gateway between the Caribbean markets and the United States of America. We have the ability to expand into emerging sectors, digital services, renewable energies, fintech, and supporting our blue economy in ways that we've never imagined. We can attract investment, create more jobs, and build a resilient, diversified economy that reduces our dependency on limited revenue streams. And most importantly, we can ensure that the Virgin Islands is no longer on the sidelines of regional trade policy discussions, but at the table when helping to shape them. At this time, global trade dynamics are shifting rapidly, with new tariffs, supply chain disruptions, and geopolitical pressures impacting Caribbean economies. We need to look at modernizing our CBI and achieving economic security, workforce development, and regional influences to support long-term sustainability. Colleagues, I wanted to take this time out to thank each and every one of you when this bill was first heard for your recommendations, which have all been incorporated in addition to additional amendments from the stakeholders that were part of the bill, to include Attorney David Bornn, who is here with us today, who is one would say, expert in the Caribbean Basin Initiative, as he has been representing the government of the Virgin Islands in such cases. The amendment number is 36-724, and colleagues, I urgently request for your support on this measure. Thank you, Madam Chair.
And thank you, Senator Bolques, for your introduction of this bill. I signed on to it because I've been very concerned that we're not getting our full, rightful share of the funding that we're entitled to in the Virgin Islands. Attorney Bornn, welcome to the Earl B. Otley Legislative Chambers. How you doing?
Madam Chair, I am pleased to be here. Thank you.
Oh, good, good. I'm glad that you are pleased to be here. We now invite you to read into the record your submitted testimony.
Thank you, Madam Chair. My name is David Bornn. Good day, Honorable Senator Carla Joseph, Chair of the Rules and Judiciary Committee, other committee members, other senators present, and members of the listening and viewing audience. My name is David A. Bornn, and I appear before you today as an individual citizen and a resident of the USVI with an interest in the development of the role of the U.S. Virgin Islands in the Caribbean Basin. I seek to provide testimony in support of Bill number 36-0194 and Amendment 36-724. The Virgin Islands are in a truly unique, stable, and beneficial position within the Caribbean region. It is also unique in its ability to assist and encourage other non-U.S. Caribbean jurisdictions to utilize the USVI for their economic benefit. First, the USVI, while being part of the United States of America, is outside of the United States Customs Zone, pursuant to the provisions of the 1917 Treaty of Cession from Denmark to the U.S., whereby it was established that the existing Danish customs system and rates would continue to apply in the new territory separate and apart from the U.S. customs system. This is by Act of Congress of March 3rd, 1917, in sections 24 and 25. The USVI imposes a flat 6% customs duty on all items entering the USVI customs zone. Second, the USVI is outside the U.S. customs, because the U.S. is outside the U.S. customs zone, it is also not subject to the tariff regimes imposed by the United States. These two unique factors have come into play strongly recently as the United States has imposed significant tariffs on a global scale, including Caribbean countries and points of origin, on an erratic and unpredictable basis. And even though the United States Supreme Court recently has struck down the National Emergency Protective Act under IEEPA, the global tariffs regime remains, it's a distinction, the global tariffs regime remains against most all countries, including jurisdictions, at a 10% of value rate. This imposition of tariffs is in excess of the agreed 3.5% rate for Caribbean Basin Initiative countries and has become a sore point for Caribbean jurisdictions. Caribbean countries entered into the Caribbean Basin Economic Recovery Act, CBERA, and the Caribbean Basin Trade Partnership Act, CBTPA, thinking that they would be given preferential access to the U.S. market. As the U.S. is not a separate country, it is not a signatory or participant in any of the CBI programs. Further, the U.S. Trade Representative in April of 2025 entered a ruling that the United States would impose significant port entry fees on Chinese-built vessels coming into U.S. ports. But the USVI was granted a significant exemption in that the ruling provided an exemption for all vessels entering a U.S. port in the continental U.S. from a voyage of less than 2,000 nautical miles from a foreign port or point, and vessels of a certain smaller sizes. This is a notice of the USTR in Section 301 investigation, in Annex 2 in particular. This ruling, which has been temporarily stayed, will impose significant additional costs for shipments from the Eastern Caribbean countries beyond the 2,000 nautical mile exemption. Here enters the value of the USVI. The USVI can act as a transshipment point. The USVI can serve as a place to undertaking the processing of raw materials into finished products for entry into the United States without further duty if they undergo what is called substantial transformation in the USVI. And the USVI offers tax incentives for establishing such operations within the South Shore trade zone that involve customs duty-free and tariff-free entry of raw products to the USVI, but also the potential for duty-free entry of a USVI/US-made product in the into the US mainland market due to the unique characteristics of the USVI. Hence, Bill 36-0194 and the amendments thereto to the bill should be strongly and favorably approved, as this legislation seeks to carefully present not only the options for favorable use of the USVI by other Caribbean countries, but also seeks to have the relevant federal government departments administering the CBI program consult with the USVI, utilize and promote the unique programs of the USVI for the benefit of CBI countries, and utilize the USVI as a means of economic outreach to the CBI countries. And from the CBI countries' perspective, the inclusion of the USVI as a part of the CBI program promotion enables the CBI countries to recalibrate their access costs to the US market. As an example, how and where the USVI should be included in the CBI discussions, I have attached a press release from the State Department noting that a Caribbean Port Development Roundtable was convened on April 20th, this week, with Caribbean partners, their label. Why was the USVI not included? For reference purposes, I've also attached copies of the latest CBERA annual report on the functionality of the CBI, and also a copy of the USTR Notice of Action on its Section 301 investigation relating to the entry of Chinese-built vessels, Chinese-built or owned vessels entering U.S. ports from the Caribbean and elsewhere. Thank you for receiving this testimony, and I remain available for your questions.
Thank you so much, Attorney Bornn. And before I go into the first round, and we're looking really at having only one round of 4 minutes, and if we need to ask any other burning questions, I would have any senator so indicate. But I do have a very pressing question, because we're talking about the Caribbean Basin Initiative. And just for some background context, because we also have our listening audience, the Virgin Islands typically receives $6 million a year. For the past years, we were receiving about $6 million from the U.S. Department of Treasury for that's rum that has been sold outside of the Virgin Islands and imported into the United States proper. Now, my bone of contention, and that's why I signed on to this is my big bone of contention, is that we haven't been getting our fair share since we now have Diageo operating in the Virgin Islands. And now I'm hearing from your testimony, we are not even at the table in certain instances to have a really productive and be able to build our case why we are due certain monies that were promised but never delivered based on the formula. So my question is, where do you see this bill? I know Senator Bolques has an amendment coming forward. Where do you see that this bill will be majorly impactful in us being able to give a strong, very strong and key position that we would like our fair share based on the calculations that is put forward on this program.
David Bornn, Senator, I need to unpack a little bit of what you've said
Okay.
to correct a few points there. First of all, the CBI is only for Caribbean Basin Initiative is only for non-U.S. countries. And any of the funding that is funneled through the CBI is for those non-U.S. Caribbean territories. So the money that we get, I'm going to come back to this in just a minute in a different way, would not be the same funding that is for CBI partnered countries.
I understand that.
Okay. However, what this bill seeks to do is to raise our hand and say, hey, we are a U.S. territory within the region that you're trying to reach. We are in competition with China for getting the attention of the other Caribbean countries. And the Chinese outspend the United States in terms of Caribbean expenditures, Caribbean funding by 3-1. Second, the $6 million that you reference in terms of the rum revenue funds, those are based upon the rum production from other Caribbean islands that is imported into the U.S. And it's split between Puerto Rico and
the U.S. Virgin Islands.
Right. So that is limited in terms of the amount of production that they make and that comes into the U.S. And one of the reasons why that production may not be significantly larger is just this issue of entering with duties and with these shipping issues of getting into the U.S. So they have been able to find alternative markets.
So you are basically saying that some of our neighbors are utilizing alternative markets outside of the United States, and that is causing us to have a bit of a challenge.
Correct.
With getting funding and getting the amount of revenue generated that we normally would have.
Correct.
Okay, I understand.
And further, in part because they don't know that they could use us as a stepping stone.
Right, because we have some exemptions.
Right. But the CBI program does not promote us as being that intermediary. So I'm saying this bill, this resolution saying, hey, we're here, is to say Department of Commerce, Department of Treasury, U.S. Trade Representative, when you're dealing with the other Caribbean countries, let them know that there are some programs in the USVI that may be beneficial.
And that is one of the key reasons why I said what I said, so that you could elaborate further. So it's clear where we're taking this resolution, and to be sure, because I read your testimony, and we aren't at the table in some of the instances when these matters are being discussed. At this time, I will recognize Senator Avery Lewis for your first 4 minutes.
Thank you, Madam Chairwoman. Attorney Bornn.
Good day, Senator.
I think the gravity of this, what we're discussing here today, I'm going to ask you to take at least a minute of my time and just explain to the community what we're really trying to achieve here today based on this bill. Because a lot was said, and I want them to understand exactly what we are trying to achieve. So just take a minute of my time and explain to the community.
Simply put, Senator, it's that we as residents and partners in the Caribbean with our Caribbean neighbors, but being U.S. and so not part of the what is called the Caribbean Basin Initiative program, we don't benefit from that program, but we can benefit if what the unique properties of the USVI are were promoted to the other Caribbean countries so that we can act as a conduit for them to access the U.S. market.
All right. And if and when this resolution is passed, whose hands do we really would like for it to get into to make a change?
Well, it has to be directed to the U.S. Department of Commerce, the U.S. Treasury, and the U.S. Trade Representative. They are the agencies responsible for the CBI program.
So no one particular lobbyist or team?
Well, I think the intent of this resolution is to go directly to those agencies by whatever, I mean, there can be an intermediary, but it needs to go directly to those agencies.
Good, because I read the amendments and, I think it's a good thing that we should be included and make sure that we got everything that is rightfully due for us, just like when we lobbied for the rum cover over and so forth. Now we have our permanency. I think that still could have been more in my eyesight.
We'd only be, we've hit the cap. The 1325 is the cap.
Okay, well, a cap on your eyes, not in my book. But anyhow, with this, I do understand the intent of the bill sponsor. I thank him for definitely coming forward. I thank you for being here today. I really didn't have no questions. I just wanted that the community understand and we break it down in layman terms that they understand what we're trying to achieve here today.
Yep.
And also in a small territory while we don't have a vote, it's always best that we, do what we could do to impress our beliefs and our needs and our wants and what we're entitled to. We have to fight. I'm a firm believer in when it's a closed mouth, don't get fed. So we have to speak up for ourselves.
1 minute.
And in due time, I'll take the appropriate actions on this.
Thank you, Senator.
Thank you so much, Senator Lewis. The chair will now recognize Senator Clifford Joseph for your 4 minutes. Kindly proceed, Senator Joseph.
Thank you, Madam Chair, for the time. Good afternoon to the listening public. Good afternoon to everyone in the legislature. Good afternoon, Mr. Bornn. How are you doing?
Good afternoon, Senator.
I first would like to thank the bill sponsor for taking the time out to get this resolution together. I see that it took some time from the 35th. So you were doing some work for a little bit. So they say nothing good comes easy. So it'll take time to make things good. Mr. Bornn, I too don't have much questions for you, but I'd like to know for sure, like in raw materials, when we say raw materials from other Caribbean islands or what we produce here in the Bornn Islands?
David Bornn, Senator, it's both.
Okay.
But this bill is particularly geared towards extending the notice to other Caribbean islands that their raw products coming here and being transformed. I'll give you an example. Papaya,
yes,
or mangoes being brought here, processed into juice.
Yes.
That process would qualify for that product, that end product, to then be treated as made in the USVI/USA and enter the U.S. as a U.S.-made product.
Okay, good.
No duty. No, if it's done in the trade zone, no customs duty, no tariff in, and no outbound duty to the U.S. market because it's now a U.S. product. So what we're trying to suggest is that these islands, as a means of lowering their cost of getting goods to market, could use this process. In addition, as I mentioned, they are also having issues with the shipping costs. And so we could act as that in-between point because we do have the exemption to get to the U.S. at a lower cost.
The lower cost. So regardless of the type of ship, it wouldn't make a difference because...
No, they specifically authorized smaller ships, which Tropical uses.
Okay, good.
Tropical and all the others use smaller vessels than they do for the longer haul.
Yes.
But whatever size vessel, it could still go in.
Well, thank you for your response. Madam Chair, I don't have any more questions. Mr. Bornn. Thank you.
Thank you so much, Senator Clifford Joseph. At this time, the chair will recognize Senator Alma Francis Heiliger for your 4 minutes.
Thank you so much, Madam Chair. Good day to my colleagues. Good day to the people of the territory, to the testifier. I wanted to touch a little bit. I fully understand the positive that could come about if we were able to participate. What are the potential negatives, if any? And if there are none, share that. But are there any potential backlashes for us pushing forward and saying we want to participate here?
Good day, David Bornn. Senator, I am hard-pressed to think of what negative there would be because it's not that we're creating anything. Mm-hmm. It's just that we have a sleeping giant of a benefit, not just to us, but to the other Caribbean islands that not many people are aware of. And I can tell you emphatically, because I've had discussions with people from other islands, particularly at the lower end of the chain, mm-hmm. and they were not aware of this. And frankly, when you tell people about this, they say, "Oh, come on,
really?
This can't possibly be true." But it is
but
a question.
Why do you think that is? Do you think that's done deliberately, not to educate as to the possibilities as to where the U.S. Virgin Islands could be in a position to assist to that level, or it was just something simply overlooked?
I think it's mostly an issue of being overlooked.
Okay.
Although we have not promoted it ourselves in that direction. We've promoted it more in terms of goods coming from Asia or that major kind of shift. And because we're not part of CBI, mm-hmm. we're not sitting at the table when they talk about, like this week, port development.
Oh, so we're not part of those conversations.
We're not part of the conversation.
It's almost like out of sight, out of mind.
That is correct, Senator.
Yeah, I think I fully understand. Now, if we were successful with this resolution, what kind of potential jobs do you see that this could open up?
Senator, a whole lot of jobs that are not just menial jobs. It's a whole, there's port jobs for the shipping related.
Yes.
There is the processing factory jobs. There are all the...
1 minute.
All these kinds of things beget indirect other jobs. Mm-hmm. So it isn't that you have to focus only on the jobs that are in the trade zone. It's when these companies establish an operation here, it's like the refinery. People didn't realize how much the refinery impacts outside of the refinery fence.
Yes.
Until the refinery
they
is
were
no
gone.
more.
Understood. And I want to talk about the potential economic impact. Local businesses or residents directly. What kind of impact would you see or could come to realization as it relates to their economy?
Well, certainly we could benefit from some of the products that they would bring. But, we're going to have things like truckers and move the stuff around. I guess I mentioned previously the shipment services, but again, it's a multifaceted element depending upon the type of business. There's no one set of types of benefit that we would get.
Okay, understood. Let's say again, we get this pushed through. How long do you anticipate that something like this would take to be established so that at some point we would actually start to see some type of benefit from it?
That is an open question.
Okay.
Because it essentially depends how directly and how quickly
And how
you
eager.
get it into the hands, and on the other end, how eager they are to accept the point of reference to the agencies that are dealing with the CBI program.
Good. Well, I will say this. For me, I don't have a problem with this because for me, anything that could potentially expand and open doors for us, whether it's through assistance, projects, residents, or economy, this almost sounds like a win-win situation. And if we do get this pulled off, I will be very, very happy because at the end of the day, we all choose to represent the people and make decisions to impact their lives. And we all wish that it's being done in a positive way. And if this could assist in any which way, shape, or form, as their representative, I will be happy to support it. Thank you so much, Madam Chair, for the time.
Thank you, Senator Francis Heiliger, for your line of questioning. The chair will now recognize Senator Milton Potter for your 4 minutes.
Thank you very much, Madam Chair. Good afternoon, colleagues, and good afternoon to Testifier Attorney Bornn. Attorney
afternoon,
Bornn,
Senator.
how are you doing today?
Good, thank you. And you?
Good, thank you. Attorney Bornn, you know that the USVI is not a signatory or participant in any CBI programs because it is not a separate country. Given that structural reality, what specifically does the resolution ask the federal government to do? Create a new consultation mechanism, amend existing CBI regulations, or something else? And realistically, how receptive has the federal government been to similar VI requests in the past, if you are aware?
Thank you, Senator David Bornn. Understand that I'm not part of the drafting of this particular bill or the amendments, but I have looked at them, I've reviewed them and approved them. But the element that this resolution seeks to do is based upon the fact that we have not been involved in any way in the consultative process of the federal government working with the CBI countries. That's number one. Yet we are a U.S. outpost in the Caribbean, part of this group of countries or jurisdictions that the CBI program works for. The closest being the BVI. The second is that this current process of tariffs has created quite a bit of discontent in the Caribbean. So from a Caribbean country's perspective, they want to see something done. They are quite upset that they're paying a 10% tariff where they had agreed to a 3.5. Third, the CBI agreement comes due for renewal in 2030. And so it's now time to start thinking of, okay, if you're going to update this agreement, hey, we're over here. Can you include us in the new agreement?
Understood. Now, Eastern Caribbean countries beyond the 2,000 nautical mile threshold face significant new costs under the USTR's port fee framework.
That's correct.
You suggest that the USVI can serve as a relay point for those countries.
A transshipment point.
Have you done any, are you aware, I know this is in your bill, have you done any cost modeling to demonstrate that routing through the USVI actually produces net savings for those shippers compared to direct entry to the continent, to a continental U.S. port?
Hey, Senator, I have not done any specific analysis, but if you look at the fact that the port fee, it has been held in abeyance for a short time. It's still not implemented, but it's to be implemented, is $1 million per entry of the vessel. And that's, I mean, I think that tells you everything. Whereas if the shipment were transshipped here, and the vessels coming here are exempt from this fee, they don't. That's an automatic savings. That doesn't require a great economic analysis. You can see that is a substantial impact that they are going to pay, and they are very scared that is going to happen.
Okay. I appreciate your response. I support the initiative. Kudos to the sponsor. So at the appropriate time, I'll vote in support of it. Thank you, Madam Chair.
Thank you, Senator Potter. Now, I have a question. Suppose, this abeyance, that the shipments no longer, it lasts forever, and the court rules in favor of the other foreign importers. How do we still, like China and the like, and so they don't have to pay that hefty $1 million tariff that is being proposed? How would we benefit? We won't be benefiting at all, would we? Or do you see that even should that stay in abeyance, we are going to still be able to benefit in some way, shape, and form because we have zero tariffs?
The fear of the unknown is what I think is driving the issue, because while it may not be that regime presently, as we have seen, it can happen at any time. And it is that fear, because, for instance, they went from 3.5% to 10%. 10% is in effect. That is the kind of thing that is of concern to the Eastern Caribbean.
Okay, and I think that's a very salient point, because the market becomes a little bit uncertain for a lot of exporters. And so if we can be used, and we're opening our whole transshipment port, especially in St. Croix and over here, as that conduit, as you indicated, then that helps our brothers and sisters from the Caribbean islands to still be able to reach U.S. markets at a good cost. And so I signed on to the bill because I understood what it meant for the region, ideally, and based on the concept and fundamentally. But what would the Virgin Islands get besides being the conduit? What benefits that we would get being that conduit from our brothers and sisters using our ports? You could list some of them so we could be very clear on how that is going to help also to grow our local economy. If you could just enumerate or delineate on those benefits.
Well, Senator, let me clarify. This is not simply a matter of transshipping. The ship comes, unloads, goes to the other. That's only one part of the the offering. The more significant element that we benefit from would be bringing the raw products here and then processing them and creating a transformed new product for shipment and entry into the United States market at a substantially lower cost than it would be if it was coming directly from St. Lucia, Trinidad. And that would generate for us infrastructure, factory infrastructure with jobs and expenditures and indirect revenue from what the factory needs and the factory people need to operate. And this can proliferate into any number of types of factories. And it isn't simply limited to the Eastern Caribbean. I mean, we're talking about Eastern Caribbean in this bill.
Noted.
But just know that the same principle applies to any other country.
So basically, conceptually, you could have goods being shipped from, say, Taiwan, raw goods, and they go to, say, St. Lucia.
Right.
And then St. Lucia, and the end port would be the United States.
Right.
Then St. Lucia would then ship them here to be assembled or what have you.
Well, it has to be more than assembled. That's the key. It has to be a raw product, no more than 70% of the final value of the product. But as long as they can meet that test when they finalize the final product for market.
So it has to have some type of, so that's the 70%, but it has to be assembled. I will say assembled.
You can't just bring it, put it in a new paper bag and
No, but
put
it could be like a computer.
Yes.
Could be like a computer, and you're bringing all of the raw materials that's manufactured or outside of the U.S., and then you are putting this whole computer laptop together, and you're testing it and doing all of those things. And then from there, you export the full product to the United States for sale. Is that how it works fundamentally? And that's what we are thriving to achieve, to open this up to our brothers and sisters so that they can benefit from our free trade zone.
Right.
Okay, so that's what I thought.
And
I'm trying to break it down so that our lay people could understand the impact of this resolution. And it is just a resolution so that we can say, hey, we want a seat at the table. Hey, we want to sit in negotiation with you, and to show you that, you can have certain benefits and incentives if you locate in the Virgin Islands. So this is part of a mechanism to incentivize factories and businesses to come to the Virgin Islands.
You're spot on.
Okay, all right. I was ready to vote long time because I understood clearly the significance of it as far as expanding our industries, whether it's watchmaking that we used to have, technology, even any other raw goods, purses or what have you, anything that we could offer this, but we need to have first a seat at the table and let these persons know, the Department of Treasury, all of these individuals, that, hey, we want a seat at the table to have a discussion with our Caribbean brothers and sisters regarding the benefits of locating some of their businesses
That's exactly
here.
the placement of this resolution.
Okay, I understood it clearly. I just wanted to make sure that we here as a body understands it clearly as well. Okay, thank you. Do I hear amendment?
Amendment. Oh. Amendment, Madam Chair.
Senator Angel Bolques Jr., you're recognized for your amendment.
Thank you, Madam Chair. Madam Chair, I move amendment number 36-724, amendment to bill number 36-0194. Bill number 36-0194 is amended in the following instances. A, on page 1, after the second whereas clause, insert the following three whereas clauses. Whereas the Virgin Islands possesses a unique posture being geographically located in the Caribbean and a territory of the United States, where goods may be shipped to the territory for transshipment into qualifying vessels for entry into United States, consistent with applicable federal law, and whereas the
I heard a motion. Senator Avery Lewis, you're recognized for your motion.
Thank you, Madam Chairwoman. I move to waive the reading of amendment number 36-724. I so move.
Second.
The motion to waive the reading of amendment number 36-724 has been properly made by Senator Lewis, seconded by Senator Joseph and Bolques.
I so move.
Hearing no objection, so carries.
Motion. Motion.
Go forward. You said I so move?
Yes.
I so move. Who said seconded? Who seconds the motion? Thank you. The motion to amend Bill number 36-0194 by amendment number 36-724 was properly moved by Senator Bolques, seconded by Senators Lewis and Joseph. Hearing no objection, the amendment carries.
It's amended now. Motion. Madam Chair, I move bill number 36-0194 as amended, a resolution urging the United States Congress and the Office of the United States Trade Representative to expand and modernize the Caribbean Basin Initiative, CBI, to further support economic growth and development in the Virgin Islands and the wider Caribbean region, to be forwarded to the full body for further action and consideration. I so move.
Bill number 36-0194 has been properly moved by Senator Bolques, seconded by Senator Potter and Lewis. Roll call on bill number 36-0194 as amended.
Senator Angel L. Bolques Jr. Senator Bolques Jr., yay. Senator Kenneth L. Gittins.
Yes.
Senator Gittins, yay. Senator Alma Francis Heiliger. Senator Francis Heiliger, yay. Senator Carla J. Joseph.
Yes.
Senator Joseph, yay. Senator Clifford A. Joseph Sr. Yes. Senator Joseph Sr., yay. Senator Avery L. Lewis. Yes. Senator Lewis, yay. Senator Milton E. Potter. Yes. Senator Potter, yay. Madam Chair, you have 7 yeas.
Thank you, Madam Clerk. Bill number 36-0194, a resolution urging the United States Congress and the Office of the United States Trade Representative to expand and modernize the Caribbean Basin Initiative, CBI, to further support economic growth and development in the Virgin Islands and the wider Caribbean region, as amended, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further action and consideration. At this time, we will ask Attorney Bornn to present 30 seconds closing remarks.
Well, good afternoon again, everybody. I'm not quite sure what one says in closing on a resolution, but I think that you should all be commended for acting favorably on this, because I think you are wholeheartedly pushing the Virgin Islands economic development to the front.
And that's exactly what you say when you're making those closing remarks. Very good, Attorney Bornn. Point of personal privilege, Senator Angel Bolques Jr.
Thank you so much, Madam Chair. I just wanted to publicly thank Attorney David Bornn for his insightful support and provided a lot of good dialogue as we met several times in discussion of this resolution. And being that he already had insurmountable experience in this area, it was a lot more easier than I anticipated it would be. So again, Attorney Bornn, I really appreciate all of the help and support that you've provided for this bill. And thank you for being here with us today again.
Most welcome, Senator.
Thank you, Madam Chair.
And thank you so much, Attorney Bornn. You are relieved from your presentation here and present here in the Earl B. Atlee Chambers for the Committee on Rules and Judiciary. Clerk, Madam Clerk, kindly proceed with reading the final block of today's agenda into the record.
Block 3, bills. Bill number 36-0009, a resolution honoring and commending Mr. Stephen Van Bieberhout for his years of dedicated service and numerous contributions to the people of the Virgin Islands, proposed by Senator Milton E. Potter, sponsored by Senator Angel L. Bolques Jr., and co-sponsored by Senator Ray Fonseca. Bill number 36-0207, an act amending Title III, Virgin Islands Code, Chapter 25, Subchapter 6, by adding Section 590D, and Title 24, Virgin Islands Code, Chapter 1, by adding Sections 24, requiring employers to grant parents and legal guardians of a child with a diagnosed disability 2 hours per month of paid leave to attend the child's medical appointment. Proposed by Senators Avery L. Lewis, sponsored by Senators Angel L. Bolques Jr., Clifford Joseph Sr., Kenneth L. Gittins, and Maurice C. James. Bill number 36-0236. An act amending Title 33, Virgin Islands Code, Subtitle 3, Chapter 111, Section 3061, by increasing the number of money that is to remain in the Virgin Islands Insurance Guarantee Fund before an interest can be deposited into the general fund. Proposed by Senator Kurt A. Vla, sponsored by Senators Avery L. Lewis, Dwayne M. DeGraff, and Clifford A. Joseph Sr. Bill number 36-0258, an act reprogramming administrative fees resulted from the bonds issued for the Fortress Investment Group, transferred for various projects and initiatives to enhance the economic development of St. Croix and to be deposited into the Budget Stabilization Fund. Proposed by Senator Kurt A. Vla, sponsored by Senators Avery L. Lewis, Dwayne M. DeGraff, and Clifford Joseph Sr., and co-sponsored by Senator Herbert L. Frederick. Bill number 36-0232, an act amending Act number 8018 to authorize the disposal of green waste using controlled incineration technologies, including air curtain incinerators, and for other purposes. Proposed by Senator Clifford A. Joseph Sr., sponsored by Senators Avery L. Lewis, Kenneth L. Gittins, and Franklin D. Johnson. Bill number 36-0149, a resolution honoring and commending Janeisha John for her outstanding achievements, pioneering spirit, and significant contributions to the field of entertainment, modeling, and television production, celebrating her role as a cultural ambassador, trailblazer, and inspirational leader of the Virgin Islands. Proposed by Senator Angel L. Bolques Jr. Bill number 36-0238, an act amending Title 29, Virgin Islands Code, Chapter 23, to redirect hotel development net bonds proceeds to the government employees retirement system of the Virgin Islands, proposed by Senator Avery L. Lewis. Bill number 36-0257, an act transferring parcel number 2C Estate Ross, 8 New Quarter, St. Thomas, from the Virgin Islands Housing and Finance Authority to the Virgin Islands Department of Education for the use by the Charlton-Mali High School, proposed by Senator Avery L. Lewis. Bill number 36-0275, an act approving the amended lease agreement between the government of the Virgin Islands, acting through the Commissioner of the Department of Property and Procurement and Hearts in Service Association, Inc., for leasing of parcel number 175C, Estate Anna's Retreat, number 1, New Quarter, St. Thomas, for the purpose of providing eligible programs and services to homeless families, individuals, veterans, and at-risk youth, and the operation of a soup kitchen and other related purposes. Proposed by Senators Milton E. Potter, Marvin A. Blyden, Avery L. Lewis, by the request of the Governor. Madam Chair, this ends the reading of today's agenda.
Thank you, Madam Clerk. In this block, we have a total of 9 bills. And so they range from resolutions. We have 2 resolutions and 1 lease agreement. So do I hear a motion? Do I hear a motion? Senator Milton Potter, you're recognized for your amendment.
Oh, we're going straight to amendment?
Yes.
Thank you, Madam Chair. Amendment? I didn't know we were moving straight to amendments.
You're making an amendment to bill. Go ahead with your amendment.
Thank you very much, Madam Chair. Madam Chair, colleagues, I offer amendment number 36-722 to bill number 36-0009. Bill number 36-0009 is amended by designation section 2 as section 3 and inserting the following new section 2. Section 2, the building located at 2315 Crown Princeton's Garda, Charlotte-Mali, St. Thomas, must be named the Stephen Van Beverhout Inspector General Building. The Office of the Virgin Islands Inspector General shall erect signage at the main entrance of the building bearing the inscription, the Stephen Van Beverhout Inspector General Building. If the Office of the Virgin Islands Inspector General is located, the successor the successor building or any successor buildings must be named the Stephen Van Beverhout Inspector General Building. I so move.
Second.
Amendment number 36-722 to bill number 36-0009 has been properly moved by Senator Potter, seconded by Senator Lewis and Francis Heiliger and Joseph. Hearing no objection, so ordered.
Motion.
Kindly proceed with your motion, Senator Potter.
Thank you, Madam Chair. Madam Chair, colleagues, I move that bill number 36-0009, a resolution honoring and commending Mr. Stephen Van Beverhout for his years of dedicated service and numerous contributions to the people of the Virgin Islands, as amended, be favorably voted upon in the Committee of Rules and Judiciary and forwarded to the full body for further consideration and action. I so move.
Second.
Bill number 36-0009 as amended has been properly moved by Senator Potter, seconded by Senator Bolques Jr., as well as Senator Francis Heiliger. Roll call on bill number 36-0009.
Senator Angel L. Bolques Jr. Yay. Senator Bolques Jr. Yay. Senator Kenneth L. Gittens.
009 again? Yes.
Senator Gittens Yay. Senator Alma Francis Heiliger.
Yes.
Senator Francis Heiliger Yay. Senator Carla J. Joseph.
Yes.
Senator Joseph Yay. Senator Clifford A. Joseph Sr. Yes. Senator Joseph Sr. Yay. Senator Avery L. Lewis. Yes. Senator Lewis Yay. Senator Milton E. Potter. Yes. Senator Potter Yay. Madam Chair, you have 7 yeas.
Thank you, Madam Clerk. Bill number 36-0009, a resolution honoring and commending Mr. Stephen Van Beverhout for his years of dedicated service and numerous contributions to the people of the Virgin Islands, as amended, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. Amendment, Senator Avery Lewis. Media, could you kindly turn on Senator Lewis's mic? Try again.
Thank you. Madam Chairwoman, I offer I move amendment number 36-778 to bill number 36-0207. Bill number 36-027 is amended in the following instances. In section 1, internal section 590D, in subsection A.
Point of order.
A.
Point of order. Point of order.
Yes, Senator Gittens, which rule is being violated? You don't have the amendment?
The measure has to be called for there to be an amendment to be offered. An amendment is being offered, but to what? We haven't called up the bill yet.
Well, we read the bills into the record.
Yes, that's what you did, but we need to call each bill so that each bill could be voted upon. Once the bill is called, then you offer an amendment.
Ask the attorney.
Hey, we're done? Ready? Go ahead.
Okay. Madam Clerk, call up bill, the second bill, and the agenda. Thank you, Senator Gittens.
Bill number 36-0207, an act amending Title III Virgin Islands Code, Chapter 35. Bill number 36-0207, an act amending Title III Virgin Islands Code, Chapter 25, subsection 6, by adding section 590D and Title 24 Virgin Islands Code, Chapter 1, by adding section 24, requiring employers to grant parents and legal guardians of a child with a diagnosed disability 24 hours per month of paid leave. 2 hours per month of paid leaves to attend the child's medical appointments. Proposed by Senators Avery L. Lewis, sponsored by Senator Angel L. Bolques Jr., Clifford Joseph Sr., Kenneth L. Gittens, and Marie C. James.
Thank you. We are now on bill number 36-0207. Do I hear an amendment? Senator Lewis.
Thank you, Madam Chairwoman. Madam Chairwoman, I move amendment number 36-778 to bill number 36-0207. Bill number 36-0207 is amended in the following instances. In section 1, internal section 590D, 1 in subsection A, strike paragraph 1 in its entirety and insert a new paragraph. 1. Child with a diagnosed developmental disability means a child who is under the age of 22 years and has undergone evaluation and received a professional diagnosis of a developmental disability. B. redesignate paragraph 2 as paragraph 3 and insert a new paragraph 2. 2. Developmental disability means a group of chronic conditions including autism, cerebral palsy, and intellectual disabilities that persist throughout a person's lifetime and impair physical, learning, language, or behavioral function, and which result in significant limitations in daily activities and create a need for specialized long-term support. In subsection B, insert developmental before disability and strike 2 hours and insert 4 hours.
Senator Clifford Joseph, you're recognized for your motion.
Motion, Madam Chair. I move that we waive the reading of Amendment 36-7778. I so move.
Do I hear a second? Motion made by Senator Joseph, seconded by Senator Francis Heiliger and Bolques to waive the reading of amendment number 36-778. Hearing no objection, so ordered. I so move. Motion made by Senator Avery Lewis and seconded by Senator Alma Francis Heiliger. Hearing no objection on the amendment, it is carried.
Thank you. Thank you, Madam Chair. Motion?
You're recognized for your motion, Senator.
Thank you, Madam Chairwoman. I move Bill number 36-0207 as amended, an act amending Title 3 Virgin Islands Code, Chapter 25, Subchapter 5, by adding Section 590D and Title 24 Virgin Islands Code, Chapter 1, by adding Section 24, requiring employers to grant parents or legal guardians of a child with a diagnosed disability 2 hours per month of paid leave to attend the child's medical appointments. I so move.
Second.
Bill number 36-027, as amended, has been properly moved by Senator Lewis, seconded by Senator Francis Heiliger, Senator Potter, Joseph, and Bolques. Roll call on bill number 36-0207.
Senator Angel L. Bolques Jr. Senator Bolques Jr., yay. Senator Kenneth L. Gittins.
Yes.
Senator Gittins, yay. Senator Alma Francis Heiliger. Yes. Senator Francis Heiliger, yay. Senator Carla J. Joseph.
Yes.
Senator Joseph, yay. Senator Clifford A. Joseph Sr. Yes. Senator Joseph Sr., yay. Senator Avery L. Lewis. Yes. Senator Lewis, yay. Senator Milton E. Potter. Yes. Senator Potter, yay. Madam Chair, you have 7 yeas.
Thank you so much, Madam Clerk. Bill number 36-0207, an act amending Title 3 Virgin Islands Code, Chapter 27, Subchapter 6, by adding Section 590D and Title 24 Virgin Islands Code, Chapter 1, by adding Section 24, requiring employers to grant parents or legal guardians of a child with a diagnosed disability 2 hours per month of paid leave to attend the child's medical appointment as amended has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further action and consideration. The next bill that we have on the agenda is bill number 36-0236. Do I hear a motion?
You don't.
Senator Clifford A. Joseph, you are recognized for your motion on bill number 36-0236.
Thank you, Madam Chair. I move bill number 36-0236 An act amending Title 33, Virgin Islands Code, Subtitle 3, Chapter 111, Section 3061, by increasing the amount of money that remains in the Virgin Island Insurance Guarantee Fund before any interest can be deposited into the general fund. Be approved by this committee of Rules and Judiciary and forward on to the full body for further consideration. I so move.
Bill number 36-0236. The motion has been properly made by Senator Joseph, seconded by Senator Bolques and Potter. Roll call on bill number 360236.
Senator Angel L. Bolques Jr. Senator Bolques Jr., yea. Senator Kenneth L. Gittens. Senator Gittens not voting. Senator Amma.
Yes, yes.
Senator
I stated
Gittens.
yes. Sorry.
Senator Gittens, yea. Senator Amma Francis Heiliger. Yes. Senator Francis Heiliger, yea. Senator Carla J. Joseph.
Yes.
Senator Joseph, yea. Senator Clifford A. Joseph Sr.
Yes.
Senator Joseph Sr., yea. Senator Avery L. Lewis. Yes. Senator Lewis, yea. Senator Milton E. Potter. Yes. Senator Potter, yea. Madam Chair, you have 7 yeas.
Thank you, Madam Clerk. Bill number 36-0236, an act amending Title 33 Virgin Islands Code, Subtitle 3, Chapter 111, Section 3061, by increasing the amount of money that is to remain in the Virgin Islands Insurance Guarantee Fund before any interest can be deposited into the general fund, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. Roll call on bill number 36-258. Do I hear a motion? Motion. Senator Lewis, you are recognized for your motion.
Thank you, Madam Chair. Madam Chair, I move bill number 36-0258, an act reprogramming administrative fees resulting from the bonds issued for the Fortress Investment Group transfer for various projects and initiatives to enhance the economic development of St. Croix and to be deposited into the Budget Stabilization Fund. And I'm favorable, it will be voted upon favorably in this committee, Rules and Judiciary, and be forwarded to the full body for further vetting and consideration. I so move.
Bill number 36-0258 has been properly moved by Senator Avery Lewis, seconded by Senator Bolques Jr. and Joseph. Roll call on bill number 36-0258.
Senator Angel L. Bolques Jr. Senator Bolques Jr., yea. Senator Kenneth L. Gittens.
Yes.
Senator Gittens, yea. Senator Alma Francis Heiliger. Yes. Senator Francis Heiliger, yea. Senator Carla J. Joseph. Yes. Senator Joseph, yea. Senator Clifford A. Joseph Sr. Yes. Senator Joseph Sr., yea. Senator Avery L. Lewis.
Yes, yes.
Senator Lewis, yea. Senator Milton E. Potter. Yes. Senator Potter, yea. Madam Chair, you have 7 yeas.
Thank you so much, Madam Clerk. Madam Clerk and colleagues, bill number 36-0258, an act reprogramming administrative fees resulting from the bonds issued for the Fortress Investment Group transfer for various projects and initiatives to enhance the economic development of St. Croix and to be deposited into the Budget Stabilization Fund has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. Senator Ray Fonseca, you are recognized for your point of personal privilege.
Thank you so kindly, Madam Chair. With regards to Bill number 36-0232, the Rules and Judiciary Committee is the clearinghouse ensuring that bills are properly vetted before it becomes law. In this instance, during the last session, it was agreed that I will be allowed to submit my amendment to this bill. That was never done. The process was that I was preempted. And the person that assists me, being that this is a technical matter, had an unfortunate emergency, and so the amendment was subsequently not able to be completed until today. So the amendment is now submitted, and so I'm asking that the Rules Committee that this bill be properly vetted, and to do that, we will have to table the bill for further considerations. And here's the reason why. The machine,
Objection.
I'm talking.
Let's Senator Fonseca, and I hear the motions, and I'm going to get to them in a minute. Senator Fonseca, just sum it up, and I'm going to recognize the motion.
Well, the issue is the St. Croix location is different.
Senator Fonseca, we have a motion by
Madam
a
Chair.
member of this committee. So all grace has been expired for your point of personal privilege. That's all I wanted to
thank
be
you,
able to
Madam
say.
Chair,
Thank you. That's
for the
all I wanted you to say, to just say thank you. All right, we have a motion on the floor by a member, and I wanted to be sure to afford the senator the respect with the decorum to just say thank you. Now let's go to the motion on the floor. Media, you can now recognize a motion that is being proposed by Senator Avery Lewis.
Hello? Madam Chairwoman, I move Bill number 36-0232, an act amending Act number 8018 to authorize the disposal of green waste using controlled incineration technologies, including air curtain incinerators, and for other purposes, be voted upon favorably in this committee, Rules and Judiciary, and forwarded to the full body for further vetting and consideration. I so move.
Second.
Bill number 36-0232 has been properly moved by Senator Avery Lewis and seconded by Senator Clifford Joseph and Senator Gittins. Roll call on Bill number 36-0232.
Senator Angel L. Bolques Jr. Senator Bolques Jr., nay. Senator Kenneth L. Gittins.
Yes.
Senator Gittins, yay. Senator Alma Francis Heiliger. Senator Francis Heiliger not voting. Senator Carla J. Joseph. Senator Joseph not voting. Senator Clifford A. Joseph Sr. Yes. Senator Joseph Sr., yay. Senator Avery L. Lewis. Yes. Senator Lewis, yay. Senator Milton E. Potter? No. Senator Potter? No.
Madam
Nay.
Chair, Madam Clerk, please change my vote to no.
Madam Chair, you have 3 yeas, 3 nays, 1 not voting.
Thank you so much, Madam Clerk. The motion fails. And so the bill will remain in the Committee on Rules and Judiciary. Now we will have a roll call on bill. Roll call on bill number 36-0149. Motion.
Move bill number 36-0149, a resolution honoring and commending Janeisha John for her outstanding achievements, pioneering spirit, and significant contributions to the fields of entertainment, modeling, and television production, celebrating her role as a cultural ambassador, trailblazer, and inspirational leader in the Virgin Islands, be favorably voted upon in this committee, the Committee on Rules and Judiciary, and forwarded to the full body for further action and consideration. I so move.
Bill number 36-0149 has been properly moved by Senator Angel Bolques, seconded by Senator Milton E. Potter. Roll call on bill number 36-0149.
Senator Angel L. Bolques Jr.
Yeah.
Senator Bolques Jr. Yay. Senator Kenneth L. Gittins. Senator Kenneth L. Gittins not voting. Senator Alma Francis Heiliger.
Yes. I'm not sure what's going on. I said yes.
Senator Alma Francis Heiliger, yay. Senator Kenneth L. Gittins, yay. Senator Carla J. Joseph.
Yes.
Senator Joseph, yay. Senator Clifford A. Joseph Sr. Senator Joseph Sr., yay. Senator Avery L. Lewis. Senator Lewis, yay. Senator Milton E. Potter.
Yes.
Senator Potter, yay. Madam Chair, you have 7 yays.
Thank you, Madam Clerk. Bill number 36-0149, a resolution honoring and commending Janeisha John for her outstanding achievements, pioneering spirit, and significant contributions to the field of entertainment, modeling, and television production, celebrating her role as a cultural ambassador, trailblazer, and inspirational leader of the Virgin Islands, has been properly and favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further action and consideration. Do we have a roll call on bill number 36-0238? Senator Lewis, you have an amendment. Kindly proceed with your amendment.
Madam Chair.
Kindly proceed with your motion. Kindly proceed with your motion. Kindly recognize media, please recognize Senator Lewis's mic. Go ahead now, Senator.
Hello.
Lewis.
Good afternoon. Madam Chairwoman, I move amendment number 36-800 to bill number 36-0238. Bill number 36-0238 is amended in section 1, B and D by striking all language and inserting the following. D, notwithstanding any other law the government of the Virgin Islands shall transmit any net proceeds derived from the sale of the hotel development project financed under this chapter as follows: 75% to the government employees retirement system of the Virgin Islands, unless otherwise prohibited by law or applicable bond covenants, and 25% to the Virgin Islands government hospitals and health facilities corporation. I so move.
A second. Amendment number 36-800 has been properly moved by Senator Lewis, seconded by Bolques. Hearing no objection, so ordered. Roll call on bill number 36.
That's 0238 as amended.
One moment, Senator. You have a motion. Media, please recognize Senator Lewis's motion of Mike.
Thank you. I'll start over. Madam Chair, I move bill number 36-0238 as amended, an act amending Title 29 Virgin Islands Code, Chapter 23, to redirect hotel development net bond proceeds to the government employees retirement system of the Virgin Islands, that it be voted upon favorably in this committee, Rules and Judiciary, and be forwarded to the full body favorably for further vetting and consideration. I so move.
Bill number 36-0238 has been properly moved by Senator Lewis, seconded by Senator Francis Heiliger and Senator Joseph. Roll call on bill number 36-0238 as amended.
Senator Angel L. Bolques Jr. Senator Bolques Jr., yay. Senator Kenneth L. Gittins.
Yes.
Senator Gittins, yay. Senator Alma Francis Heiliger. Yes. Senator Francis Heiliger, yay. Senator Carla J. Joseph. Yes. Senator Joseph, yay. Senator Clifford A. Joseph Sr. Yes. Senator Joseph Sr., yay. Senator Avery L. Lewis. Yes. Senator Lewis, yay. Senator Milton E. Potter. Yes. Senator Potter, yay. Madam Chair, you have 7 yeas.
Thank you, Madam Clerk. Bill number 36-0238, an act amending Title 29 Virgin Islands Code, Chapter 23, to redirect hotel development net bond proceeds to the government employees retirement system of the Virgin Islands, as amended, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further action and consideration. We now have a roll call on bill number 36-0257. Senator Lewis, you're recognized for your motion.
Thank you, Madam Chairwoman. Madam Chairwoman, I move bill number 36-0257, an act transferring parcel number 2C Estate Ross, 8 New Quarter, St. Thomas, from the Virgin Islands Housing Finance Authority to the Virgin Islands Department of Education by use by the Charlotte Amalie High School. To be voted upon favorably in this committee, Rules and Judiciary, and forwarded to the full body favorably for further vetting and consideration. I so move.
Bill number 36-0257 has been properly moved by Senator Avery Lewis, seconded by Senators Bolques and Francis Heiliger. Roll call on bill number 36-0257.
Senator Angel L. Bolques Jr. Senator Bolques Jr., yay. Senator Kenneth L. Gittins.
Yes.
Senator Gittins, yay. Senator Alma Francis Heiliger. Yes. Senator Francis Heiliger, yay. Senator Carla J. Joseph.
Yes.
Senator Joseph Ye. Senator Clifford A. Joseph Sr. Senator Joseph Sr. Ye. Senator Avery L. Lewis.
Yes.
Senator Lewis Ye. Senator Milton E. Potter.
Yes.
Senator Potter Ye. Madam Chair, you have 7 yeas.
Thank you, Madam Clerk. Bill number 36-0257, an act transferring parcel number 2C, Estate Ross, 8 New Quarter, St. Thomas, from the Virgin Islands Housing Finance Authority to the Virgin Islands Department of Education for use by the Charlotte Amalie High School, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. We'll now have roll call on Bill number 36-0275. Senator Milton Potter, you are recognized for your motion.
Thank you, Madam Chair, colleagues. I move that Bill number 36-0275, an act approving the amended lease agreement between the government of the Virgin Islands, acting through the Commissioner of the Department of Property and Procurement, and Hearts and Services Association, Inc., for the leasing of parcel number 175C, Estate Anna's Retreat number 1, New Quarter, St. Thomas, for the purpose of providing eligible programs and services to homeless families, individuals, veterans, and at-risk youth, and the operation of a soup kitchen and other related purposes be favorably voted upon by the Committee of Rules and Judiciary and forwarded to the full body for further consideration and action. I so move.
Bill number 36-0275 has been properly moved by Senator Milton Potter, seconded by Senator Bolques and Francis Heiliger. Roll call on Bill number 36-0275.
Senator Angel L. Bolques Jr. Senator Bolques Jr. Yea. Senator Kenneth L. Gittins.
Yes.
Senator Gittins Yea. Senator Alma Francis Heiliger. Yes. Senator Francis Heiliger Yea. Senator Carla J. Joseph. Yes. Senator Joseph Yea. Senator Clifford A. Joseph Sr. Senator Joseph Sr. Yea. Senator Avery L. Lewis. Yes. Senator Lewis Yea. Senator Milton E. Potter. Yes. Senator Potter Yea. Madam Chair, you have 7 yeas.
Thank you so much, Madam Clerk. Bill number 36-0275, an act approving the amended lease agreement between the government of the Virgin Islands, acting through the Commissioner of the Department of Property and Procurement, and Hearts in Service Association, Inc., for the leasing of parcel number 175C, Estate Anna's Retreat, number 1, New Quarter, St. Thomas, for the purpose of providing eligible programs and services to homeless families, individuals, veterans, and at-risk youth, and the operation of a soup kitchen and other related purposes, has been favorably approved in the Committee on Rules and Judiciary and will be forwarded to the full body for further action and consideration. At this time, I would like to recognize Senator Avery Lewis for your point of personal privilege.
Thank you. Madam Chairwoman and colleagues, I'd like to thank everybody for a long day. I think we did well. One of the things I'll say here this afternoon is that, we all know dates and when things don't happen in here. They're no surprise. So some people need to really, really, really start doing their homework and coming prepared. Popping up here with papers and so forth, and wanting us to acquiesce to certain things ain't gonna just happen just so. At least not by me. Let's formalize and do the right thing. Thank you.
Thank you so much, Senator Lewis, for your comments. It's deeply appreciated and understood. Senator Clifford Joseph, you're recognized for your point of privilege.
Madam Chair, if there's one thing this man, Clifford A. Joseph Sr., to do is respect people. Respect people's place, respect people's position. Months ago, I had a bill. I brought an amendment. You brought legal counsel out on the floor to tell me I didn't have 48 hours to bring my amendment. Here it is today. Bolques spoke earlier. He asked for a point of privilege. You gave it to him. You allow a next senator. Okay, I got it. I heard.
Senator, you are out of order. You are not supposed to be calling any senator's name.
Good.
You know better than that.
Good.
You know the red. So I understand.
Another senator came here.
One moment. Media, we are not going to have no war here. Okay? I want you to speak your piece and be allowed to, but please respect the decorum of this body and this institution by not calling any senator's name. Okay? Okay. So, all right. Thank you so kindly. Go forward.
I got you. But again, a senator came in here, you gave him his personal privilege. You have to be consistent. If you want to lead and look right leading, you have to be consistent. You can't be inconsistent and do something when you want. Or if it's a St. Thomas thing, and we're going to shut down St. Croix, I don't want to go there. But that's the action that you show today. That's what it is. You're showing it clear. You're showing it clear. And that's what I'm saying. Thank you for the time, Madam Chair.
Thank you so much, Senator Joseph. Before I allow Senator Frances Heiliger her point of personal privilege, I just want to say that is not the action. I don't have any clue of what any person is going to say or what they are going to present. What I do is try my very best to be as fair as possible to all my colleagues and especially those who are my committee. Senator Frances Heiliger, you're recognized for your point of personal privilege.
Thank you so much. I just wanted to put on the record that I made the decision not to vote on the incinerator bill because one of the things I did share with the public is I wanted to make sure the amendments were in line with what I wanted for this piece of legislation. That is why I chose not to go against it nor for it. And once I see what those amendments are, I will make my final decision. As it relates, I'm not one that support this St. Thomas, St. Croix thing because we are one Virgin Islands, and at the end of the day, there are many times there are things the chair or the president sitting in that seat I'm not in support of. And sometimes I feel it could be anything, but at the end of the day, we should never create a scenario like we're pitting against each other because of the districts we live in. I have sat here and sometimes I have even felt wronged, but I've never felt it was a St. Thomas, St. Croix thing. So please, let me try to, sometimes there are days you're going to get what you want and some days you're not. That's just the situation in here, okay? Thank you so much, Madam Chair.
Thank you so much, Senator Angel Bolques Jr. You're going to be recognized, and then we'll recognize the Senate President because he'd already mentioned it. Okay, Senator Bolques. Senator Bolques, you're recognized for your point of personal privilege, and then I'll come to you, Senate President, because Senator Bolques had already motioned that he wanted a point of personal privilege.
Thank you so much, Madam Chair. I wanted to echo the sentiments of the previous senator in addition to the fact that the senator who had mentioned whatever issues or concerns in relation to the bill had provided me, and I'm assuming other senators in this chamber here today, with a number of documents to include a specific amendment and documents from the VI Local Food and Farm Council. So in relation to those documents, I was not in a position to move forward in voting without seeing the amendment, which apparently is supposed to come before us, and we can decide from there. So I just wanted to at least clarify that on the record. A number of documents were provided to me to include letters to include the position of the VI Local Food and Farm Council in regards to issues with green waste or green debris. Thank you, Madam Chair.
Thank you so much, Senator Bolques, for your commentary. This time, the chair will recognize the Senate President, Milton Potter, for your point of personal privilege.
Thank you very much, Madam Chair. I just wanted to briefly express, first of all, kudos to the bill sponsor, because I think the bill sponsor had the wherewithal for the incinerator bill. He had the wherewithal and the foresight to identify a viable solution to a long-standing issue here in the territory, that is the proper disposal of our green waste. So I definitely don't want to diminish the significance of the bill that he moved forward. My concern was putting some parameters on the burning process. That is how it is done throughout this country. There are some limitations and restrictions as to how the device will be utilized. It is part of an overall comprehensive disposal plan, to include the mulching and the composting. It is all a part of one a toolbox, a suite of services, and I thought it was imperative for us to have those some parameters built in to the legislation via the amendment. So at the appropriate time, the bill, I'm sure, is going to surface again. I will be inclined to support it once it has some parameters on how the bill, how the burning will take place. Thank you very much.
Thank you so much, Mr. President. You hit on some very key points, and I really want to thank you. I had to vote no in support of the bill because I had hoped one of the key elements that I had mentioned during the bill while it was in committee was the timing and those type of parameters to be indicated, and this would be the incinerator bill, bill number 36-0232. Those parameters were not available right now. In fact, I had actually put in an amendment, and I received a preemptive letter from legal counsel because I wanted to see that this bill gets done, and we are moving forward. Without these parameters and the suite of services, as the Senate President nicely put, then I could not vote in favor in good conscience, and I was struggling for this incinerator bill with 36-0232. So we hope that we can see the light of day with the amendments, and I did see the letters from the farmers and the like, and so that also played into another aspect. At this time, I'd like to thank everyone, my colleagues, for their attention and their attendance at today's Rules and Committee meeting. I thank my staff, central staff. You're always doing a great job behind the scene and in front of the scene. And I would also like to convey a safe and happy carnival to everyone. And the committee, with all that being said, the Committee on Rules and Judiciary meeting for Thursday, April 23rd, 2026 is hereby adjourned.